we made a mistake in petition, my lord. So I may be tagged.
Which item number? 52.
52, it's supplemented.
Ma'am, please, your lordship. So I beg to mention item number 38, lordship.
It is available.
Can you, that will be naturally taken up any other day, lordship. There is some person difficulty today, lordship. Item number 38.
38.
38,
Mr. Bora is there.
lordship.
And we have received the case diary.
Yes.
Yes. If you're going to retain the case diary, then we are giving a short.
A short date and we can retain it.
Each which is preferable. 1 week, within 1 week is preferable.
Lordship,
Whether
within one.
we have to see.
26,
26-3.
Lordship.
Okay.
Lordship, there is an interim that we can-
26-3 করে দিব. Interim be continued till next date of listing. CD be retained till next date of listing. Our বাকি to লিখব due to personal difficulty of TNP's counsel, Mr. M. Bora.
deeply
Right.
obliged.
May I please, Your Lordship. Your Lordship, I beg to mention item number 36, Your Lordship. Your Lordship, with the instruction of the petitioner, I may be allowed to withdraw the petition. Your Lordship.
Otherwise, it was a POXO matter.
Yes, Your Lordship. No interim is there.
We have here also we have received the case diary. Series diary. Anyway, he wants to withdraw.
Yes, Your Lordship.
Your good name?
I.H. Laskar.
I heard Mr. I.S. Laskar, the learned counsel for the petitioner, and also heard Mr. Who is appearing? P. Sharma. P. Sharma. P. Sharma, the learned additional PP. To stop, it is submitted by Mr. Laskar that as per the instructions of his client, he wants to withdraw the SIM. Prayer allowed. The case is accordingly disposed of on withdrawal.
High level.
Yes. If I beg to mention item number 50 of today's daily list, Lordship. In this matter, my lord, I'm appearing as the amicus, my lord. Here, my lord, the paper book was not furnished to me. Plus, my lord, what they have submitted to me, my lord, the page numbers are all wrong, my lord. Not tally with the main record, my lord. So, my lord, will direct the registry to kindly serve me a proper copy, my lord.
You are appearing for the respondent.
My lord, amicus. I'm already
Amicus.
My amicus.
All position are wrong.
My lord, I have already showcased the other side. So, my lord, may direct them, my lord.
Presentation of wrong for the which one? For paper book or
paper book.
paper book? The other side is Mr. Arbora is there.
Yes, sir.
And Mr. A. Fukan. A. Fukan, the learner amicus curiae appearing on behalf of the respondent number 2. And also heard Mr. P. Sharma, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Fukan that the copy which was the copy of the paper book which was supplied to the learned amicus is the paginations the paginations of the paper book. The paginations of the paper book are wrong, which was supplied to the amicus appearing for the respondent number 2. So accordingly, the registry is hereby directed to provide a proper copy of the paper book with correct pagination. List accordingly, it will take some time after 3 weeks. List accordingly after 3 weeks.
May it please, Your Lordship. Your Lordship, with the consent of the other side, I beg to mention item number 22. I'm seeking an adjournment, Your Lordship. Your Lordship. Counsel for
22.
Yes, Your Lordship.
Yes, why you need an adjournment?
Due to personal difficulty, my senior could not be here today.
Who is your senior? Mr. Das.
Mr. P.K. Sharma and also Mr. Das as well.
P.K. Sharma. P.K. Sharma ground to DD1. Other side, standing counsel CBI is there. Hello, you will be continuing or
No.
joining?
Yes.
When it we have to join?
The director will have to join, so we'll intimate when to join on.
Okay,
By the month of March only I'll join.
by the end of the month. So in your place, is there anyone?
That is the difficulty.
It will be very difficult because nowadays at present there are numbers of cases on CBI investigated matters,
Perhaps
especially in
by the month, end of March, they are going to appoint. I have already intimated them about the fact.
obviously.
So they are trying to get it done by end of March.
But recently all the matters are being investigated by the CBI only. So it will be very difficult. Anyway, you join first and then I'll let congratulate you. Anyway,
And the matter may come after 3 weeks, Your Lordship.
with the consent of the other side. That is the standing counsel SBI, the learned counsel appearing for the petitioner side, paid for an adjournment, stating that due to some personal difficulty, Mr. P.K. Sharma, the engaged counsel, is not in a position to argue the matter. List accordingly 3 weeks, you
3
need
weeks. I'll
3 weeks.
Simply okay.
My lord, I beg to mention for listing of a bail application, my lord. It will more than 4 years inside the jail, my lord.
Hmm?
4 years inside the jail, my lord. More than 4 years.
I said, charge-sheeted one,
Sir, it-
special to Bileke Loyasan.
yes, my lord.
Port number 3, and Baker mentioned before port number 3 only.
Sitting on division bench, and that's the problem.
No, we are trying. Since second half, he is taking the bench.
Second,
Second half, most probably, because first half DV is there.
yes, my lord.
So he will be led with the second half, maybe probability is there for second half. You make a mention over there.
Simply okay.
May I please, Your Lordship? I beg to mention item number 45, my lord. Due to the personal inconvenience of the engaged counsel, my lord, matter may be passed over for the day, my lord.
45,
45, my.
but 45 is most probably along with 44.
44, my.
So 44, you are 45, no?
45.
44 who was appearing, K. Pujari, yes, Sahu. These are only other set to 9, 44 as any. 44. Is there any? Then what to do? These are connected material. For the timing, could it happen? Yes. Let it be called first. We have note your prayer for your personal difficulty.
My lord, for the personal difficulty of the engaged counsel, my.
Who is
I am
engaged
appearing for
counsel?
order, my.
Hard her. এটা hold note এটা কৰি থব 45 ত, we're keeping a small note here and let the 44 be written and then we'll pass
Ma'am.
over it.
No, sir. May please, Your
May-
Lordship. Lordship, item number 14, Lordship. I have filed my affidavit in opposition on today, Lordship. That may be called for.
1-4.
Yes,
Okay. Affidavit in opposition.
yes. That may be called for.
Oh.
Lordship.
May it please your lordship. Okay,
Item number 14, please.
Lordship, I am praying for listing of a BA, my lord. Pertaining to NDPS intermediate quantity, my lord. If possible, tomorrow, my lord.
Sorry, court number 3. You make a mention before court number 3. Yes.
I beg to mention for listing, Your Lordship, the criminal division, Your Lordship. And it was last posted on Your Lordship.
Criminal division is also before court number 18. Make a mention before court number 18.
Possible.
May I please, Your Lordship? Lordship, I beg to mention item number 29, Lordship. Lordship, kindly.
29. Yes, what is the difficulty? It's a
Lordship,
bail
it's-
application.
It's a search matter, Lordship. Need some time for preparation, Lordship.
We have received the scan copy here, I think. Adjourn corridor. That লিখিব scan copy has already been received. You need 1 week,
Lordship, kindly listed after 2 weeks, Lordship.
2 weeks.
Yes.
Fixed কিবা দিব নেকি 2 weeks? Okay, list after 2 weeks. Good.
May I please, Your Lordship? Lordship, I beg to mention item number 8, Lordship. Kindly fix this matter at 2 p.m., Lordship. Item number 8, Lordship.
At 2, you
At
need
2,
at 2.
Yes. Obliged, Lordship.
Okay.
May I please, Your Lordship, I would like to mention item number 54 for withdrawal, Your Lordship.
Withdrawal.
Yes, or Lordship.
It was a bail application.
Yes, Your Lordship.
Your good name?
S Das.
M Das.
S Das.
কি বলে?
S Das.
S Das. আচ্ছা। You're appearing for whom? Your name is not here. You're appearing for whom?
Your Honor, petitioner. Of,
No, for P Das.
yeah,
Who
yes.
is your engaged counsel?
Your Honor, BN Upadhyay.
Upadhyay.
Your Lordship, the case is already charge sheeted, Lordship.
They wants to withdraw. Okay. Yeah, I'll make a mention for your signature also. Hard Miss MS D Das, the learned S Das, learned counsel appearing on behalf of Mr. V. N. Upadhyay. And also heard Mr. P. Sharma, the learned additional PP appearing on behalf of state respondent. Mr. Sharma submitted that this has already been charge sheeted. However, it is submitted by MS Das that as per the instructions of her client, she wants to withdraw the same. The prayer accordingly allowed, disposed of on withdrawal. Okay, it will be disposed of on withdrawal.
Objection.
Item 1.
May I please, Your Lordship? 483 bail application, Lordship. Lordship, the charge sheeted POCSO case, Lordship. Pending in Jorhat, Lordship. Special Judge, Jorhat, Lordship.
Before Special Judge Jorhat,
Yes, Lordship.
let's call for this scan copy of DLCR in connection with special POCSO case number 36/2023 arising out of Jorhat PS case number 236/2023 under section 366, 376 AB, capital A, capital B, IPC, railway section 6 of the POCSO Act.
Lordship, notice me.
Oh, sorry, notice is also there. Notice we করে দিব, huh? Only respondent number 2 is there.
Yes, Lord.
He is the informant.
Yes, Lord.
Also issue notice to the respondent number 2 through jurisdictional police station routed to the office of the registry as well as the public prosecutor. List accordingly,
2 weeks, Lord.
obviously 2 weeks. Okay, list after 2
Let's
weeks.
Item 2.
Yes.
Because the petitioner of Lordship was arrested on 7/2/2025.
17.
7/2/2025. It's already made a 40 days behind the bar matter. Lordship find a FIR at least 13.
Yes.
I see Dipankar Banik, son of late Basudev Banik, resident of Lal Ganesh, Lakhra Road, Guwahati, Swancho, being the proprietor of MS Aditi Steel Cement and director of MS Isla Marketing Private Limited, begs to state that I had employed Vikas Kumar Thakur, son of Umesh Kumar Thakur, Swancho, as godown in charge, and Sri Vishal Kumar Gautam, son of Swancho, as area sales officer of MS Aditi Steel Cement and MS Isla Marketing Private Limited, and the aforesaid employees was entrusted with responsibilities of Vikas Kumar Thakur are godown and yard stock maintenance, payment collection, preparing delivery salan properly, and responsibilities of Vishal Gautam are sales cements in market, payment collection, and preparing delivery salan properly time to time during their tenure from 24/11/2023 to 4/2/2025 and 28/2024 to 4/2/2025 respectively. The accused were assigned the responsibility of godown in charge and area sales officer as part of their official duties at the company during stock verification MS Aditi Steel Cement on 4/2/2025, it has come to notice that the accused during the course of their employment dishonestly misappropriated the stock goods in the godown which was entrusted to them, but in breach of such trust, the accused person had siphoned of 3342 numbers of cement bags with rupees 12,36,540 from the godown without consent and sold the same in open market. This is the allegation against the Malad. Petitioner is one of the accused person, Malad, and he was arrested and forwarded on Malad 7/2/2025 at page 50. Malad, in this case, Malad, the co-accused, the person who was alleged to have purchased the cement bags, Malad, they have already been released by the Ladakh trial court, Malad. What we'll find that Caesar list at page 18, nothing was recovered from the personal possession of the petitioner, nor from his home. Nothing was recovered. So, my lord, as he is behind the bar since last 40 days, my lord. At this stage, possibly allow him to go on bail, my lord. And if he is involved in this crime, my lord, we will change the trial.
Yes, sir.
So, allegation is lordship that he has misappropriated 3342 numbers of cement bags worth rupees around 12 lakhs lordship. And it's from Gorsuk lordship. So lordship can fix it next week lordship. After perusal of the case, that is because lordship will have to ascertain the stage of investigation. In Lord, page number 22, lordship will see the court below has observed investigation is in this case is still going on and there are prima facie materials against the accused person. Next week, lordship, the case that can be produced, lordship.
Next date, any date can be given next week. First week. No, he's in custody.
The other cases speaks on 27, my lord.
27.
27.
Okay, then 27. Okay, 27. List from 27. Okay, is there any?
Item 3.
May please, your lordship. Your lordship, L2 POCSO is there, and lordship petition is behind the bar at 42 days, lordship.
POCSO is also there.
POCSO is there. L2 POCSO is there.
দুইটা করে দিও ইস্যু নোটিস করে দিব to respond number 2 through jurisdiction police station routed to the office of the registry and the public prosecutor. Also call for the is it not a charge sheet?
No,
Still
not
investigation. Also call for the case diary. But notice, serving of notice, it may take two weeks minimum. But your petitioner is behind the bar since
42 days, lordship. From lordship, 6/2/2025.
42 days already.
Already, lordship. 60
And
days
the
had a
case is
period,
of 8 of section.
or 8 POCSO. Short
So
date
obviously,
maybe
Shrama,
50
it will be a statutory period is of 60 days.
Lordship, let it be on 2nd of April, lordship.
2nd of April. 2nd of April. Okay, we understand. You take steps today itself.
lordship. Oblige.
Item 4.
CD call for you.
I was arrested in execution of NBWAMI. Arrested on 13/6/2024. Page 27.
One copy may be called for lordship, charge sheet method.
Page 27.
During charge sheet, you were shown as an absconder.
Absconder. Subsequently arrested now. And NBWA was issued.
But you have filed one, earlier bail application was also there. There
Also-
you were granted bail or no?
Not. Earlier, my co-accused bail was granted.
Oh, this is it for the co-accused.
Co-accused,
Acha,
my wife, my.
acha, acha. Okay, let us see, we call for the case, scan copy of the case diary when it can be listed, Sharma.
Lordship, it will come from the registry, Lordship. It will be on
28, my lord.
4th of April, Lordship. It won't come, Lordship, 4th.
Won't come.
At least 3 weeks.
If my lord, possible 28, my lord, before Eid, my lord.
It won't come.
It won't come, I think. You are saying 4th of April. List on 4th of April.
My lord, it's
Scan copy of the LCRB call for. List accordingly on 4th of April. Yes,
I have some.
3rd of April. 3rd of April.
Lordship. I can never take any 3rd of April, Lordship. Okay, because 2nd of April maybe Eid. So, then 3rd of April, Lordship.
No, Eid is on 31st, Nikki.
31st, okay.
No, Eid is on 31st March, I think.
I am not aware, Lordship, but
2nd of April
Second
is
will
not
maybe-
Eid, I think, I don't know.
so we cannot take a chance, Lordship. Can it be a 3rd of April, Lordship?
ইমান তো পিছুৱাই যাব
That-
নোৱাৰি। You want 3rd?
Third. Oblate.
ইমান কেনেকে পিছুৱাব? Exeter schedule মতে 31st of March. It may be কিবা কাৰণত পিছুৱালেও, it may be a 1st of April. Anyway, okay.
Item 5.
Yeah, please, Lordship. NDPS case, Lordship. 660
It is-
days behind the bar, Lordship.
Charge sheeted or not yet?
Charge sheeted, Lordship.
Charge sheeted.
Charge.
How many days? He'll be hand-
660 days,
6?
60 days. No, witness has been examined, Lordship. Till date,
660.
60 days.
60.
Six-
Only 60.
No, 660 days.
660 days.
Yes.
Until then, no witness.
No witness has been examined, Lordship.
Okay, scan copy of the LCRB call for. List accordingly. It may be listed after 2 weeks. I won't give a date now. List after 2 weeks. We'll call for the scan copy. Let us see.
Apply this.
Till now, as per your instruction, no witness has been
No,
examined.
I have annexed all the documents.
Okay.
Okay.
Along with the present status report of the case.
Wait, please, your lordship. Lordship, this is a regular bail application, lordship. Intermediate quantity, lordship, 35 days in jail custody, lordship. Statutory period is 60, lordship. Is from Bishwanath Charlie, lordship. Can it be before Eid, lordship? Because, lordship, he is the owner of the vehicle. He has given a lift to the person, lordship, unknown person. He is carrying, lordship, narcotics, lordship. Heroin, lordship. That is it. Before Eid, lordship, possible from Bishwanath, lordship.
3rd of April, Lordship.
3rd of April will be after Eid, I think.
Eid, before Eid, if possible.
Biswanath, I don't know. Biswanath from Biswanath.
Next week, lordship,
Okay, then.
28.
Okay.
Highly obliged.
Twenty-eight করে দিবা। 28th of March.
7.
Wait, please, your lordship. In 483 application, my lord, the allegation is of criminal conspiracy, my lord. They have not done anything, my lord, only criminal conspiracy, my lord. They are, in this case, my lord, they are behind up, they are behind up for 56 days, my lord. But they were earlier arrested in Sutia peace case number, but in that, so far, they are now more than 4 months, they are behind the bar. But in this case, shown arrest on, my lord, 21-25. So in this case, 56 days behind the bar. Is there any call for, my lord, if possible, my lord, before Eid, my lord, if possible, my lord.
From where it has to come?
Golaghat, my lord.
Otherwise, EOP Act, etc. are also wildlife, all are there, na?
Yes.
And not only this one, you have just said that he was arrested in connection with the other case also.
Yes, he was in
Anyway,
October.
I don't know, before Eid, Sharma, will it be possible? From Golaghat. Okay.
27,
Well,
my lord.
28 Lordship.
28. Okay. We are listing it on 20.
Obligement.
51.
May I please, your lordship?
Yes.
Lordship, in this case, your lordship, there's a civil dispute going on between the accused and the informants, and they have tried to give it a color of a criminal offense, your lordship. Your lordship may kindly come to page 15 of the bail application, your lordship. This is the suit, your lordship, filed by the accused. He is plaintiff number 2. And the accused and the informant is number 10, the husband of the informant, your lordship. Thereafter, your lordship, this suit is still pending before the learned trial court in Tinsukia. In connection to the said case, a CRP IO also has been preferred before this honorable court, your lordship. Page number 35. CRP IO is pending. And an interim injunction order was passed in the suit to maintain status quo, your lordship, as per dated 12/6/2024, Annexure 3, page number 37, your lordship. Page number 38, if I may read, your lordship. Page number 38, paragraph number 3, your lordship. The defendant numbers 2 and 3 also tried to assault the plaintiff. Plaintiff means, your lordship, the accused in this case, number 1, and asked them to vacate the land by removing the house and threatened to set fire at the house. There was already a dispute going on, a civil dispute, and on the relevant day, your lordship, on 28/2/2025, the informants, they have intruded into the suit land of the plaintiff, that is the accused herein. When the accused went to the place to videograph the incident, he was attacked by the informants, your lordship. He accordingly lost the first FIR on 28/2/2025, page number 43. This is the first FIR lost by the accused herein, your lordship, against the husband of the informant, your lordship.
This is lost by the plaintiff number 2.
Plaintiff number 2, your lordship, page number 44 is the Assamese copy of the FIR. Mohodoy Muk Aji, Tarik so and so 28/2/2025, 2:05 man bozat, Dibyajyoti Fukon. Dibyajyoti Fukon is the husband of the informant, your lordship. তেওঁলোকৰ উকিল শুভজিৎ চেতিয়া দুয়োজনে মিলি দাৰে ডিঙিত ঘপিয়াই প্ৰাণে মাৰিব লৈছিল। মই কোনো মতে নিজকে ৰক্ষা কৰি থানাত উপস্থিত হৈছো। মহোদয়, তেওঁলোকৰ লগত মুনু ফুকন আছিল, মোক খেদি আহিছে। মহোদয়, উচিত বিচাৰ কৰক। দাৰে ঘাপ মৰাত মই হাতখন পাতি দিয়াত মোৰ হাতত আৰু বুকুত জখম হৈছে। He went to the police station, he lost the FIR, the accused, and the medical examination was also carried out, your lordship. Page number 45 and 46. He was taken to the civil hospital by the police for medical examination. He was given first aid and then he was sent to his home. On the next day, your lordship, on 1/3/2025, the police came to the house of the accused and they have informed the accused that an FIR has been lost by the informant that at the night of 28/3, there was a firing incident. He shot from his round with the intention to kill the informant. An FIR has been lost, your lordship. The FIR is at page 48. The lost by the informant, your lordship, in the present case. Page number 48. সন্মানপূৰ্বক নিবেদিত বিনেতন এই যে আজি ৰাতি প্ৰায় 11:30 PM মান বজাত আমাৰ ককৰাতলি গাঁৱত থকা ঘৰত হঠাতে আমাৰ গাঁৱৰ নিবাসী শ্ৰী ৰাজকুমাৰ দাস, that is the accused herein, আৰু লগত অন্য এজন আহি প্ৰথমে গালিগালাজ আৰম্ভ কৰে। তাৰ পাছত তেওঁলোকে আমাক প্ৰাণে মৰাৰ ভাবুকি প্ৰদান কৰে। সেই সময়ত মোৰ স্বামী ঘৰত নাছিল। মই যিহেতু মোৰ ল'ৰা দুজনৰ লগত আছিলো, সেয়ে আমি নিজৰ প্ৰাণৰ শংকাত ওলাই নাহিলো তাৰ পিছত তেওঁলোকে আমাক প্ৰাণে মৰাৰ লক্ষ্যৰে চাৰি যায় গুলি ফুটায় তাৰ পিছত তেওঁলোকে আমাক ভাবুকি প্ৰদান কৰি আঁতৰি যায় এতিয়া আমি নিজৰ প্ৰাণৰ শংকাত ভুগিছো গতিকে দয়ালু মহোদয়ে তেওঁলোকৰ ওপৰত বিহিত ব্যৱস্থা গ্ৰহণ কৰে যেন Your Lordship, thereafter, the accused, Your Lordship, a pistol has been recovered with 7.65 mm caliber pistol, which is being produced by the informant himself. Here, what happened, Your Lordship, the informant's father, he was a government service holder, and when he was alive, he was having a pistol with him because he was having life threat from the extremists. And that pistol, Your Lordship, it is from the, it is very old and it is completely rusted, Your Lordship. That pistol was produced by the informant. It was handed over to the police. Police has seized it, Your Lordship. Page number 53 is the seizure list. What is to be noted in this seizure list is, Your Lordship, date of seizure 1/3/2025 at 11:18 AM. One 7.65 mm pistol marked as GSF so and so. And the license, it was a licensed pistol, Your Lordship, which belonged to the father of the informant, Your Lordship. Thereafter, another pistol was seized from the informant, Your Lordship, who have lost the FIR. That pistol belonged to the one Jitul Chandra Guhai, who is also one of the party to the suit, Your Lordship. From the informant side also, Your Lordship, one pistol was recovered. Not only pistol, Your Lordship, even live ammunition was recovered from the informant side.
53 is produced by whom? Accused.
By the accused, Your Lordship. It was handed over to the police.
Anyway, it's okay, but you have submitted that there was a civil dispute.
There's a civil dispute.
Obviously, this suit is still going on.
And one more thing.
Injunction was also there.
Let's-
And on that, maybe on that class, but the question is that these all criminal cases are being brought. I mean, the story of that he was trying to shot four rounds of ammunition he have already shot. So these are the allegations. I don't think
These are
so.
the allegations, Your Lordship. There are other two sections provided, which are, Your Lordship, the bailable. Only one under the Arms Act for having illegal possession of arms. Your Lordship, there is a
The
special.
arms is, it's not the case that there was a arms in his possession or it was recovered and all, but he also used the arm in
No,
fact.
no, Lordship, he had not used it. That is the case here, Your Lordship. The pistol which was seized from the accused, it was old dated, Your Lordship. No round
No,
had been
that is
fired.
your case. They cannot be fired because it's an old one.
Old one, Your Lordship. And
But as
also,
per the allegation, it's already fired.
and also arms had been seized from the informant side also. Arms was also seized from informant.
Informant did in connection with the other FIR.
Within the same FIR, they have seized, Your Lordship.
Acha.
And also live ammunition was recovered from them.
No, but from the out of same FIR.
The same FIR, Your Lordship.
Acha.
So our case is that because this civil dispute is going on, they have planted. And one more thing that has to be noted, Your Lordship, the investigation.
Your petitioner is how long is he is behind the bar now?
Your Lordship, he was shown to be arrested on 2, but he was arrested on 1st of March itself, Your Lordship. Your Lordship, what I'm praying, Your Lordship, in this case, Your Lordship, the investigation, the police has started the investigation even before receiving the FIR, which can be seen from the record itself. The FIR was received, Your Lordship, on 1/3/2025 at 9:20 PM. And the seizure was made on 1/3 at the morning itself. Even before filing the FIR, the police had made the seizure and investigation was conducted.
So whether there is any case that the police was informed through telephone or
No,
GTNT
nothing.
was
On
there?
written FIR was lost, Your Lord. And also the.
No, written FIR was obviously lost on 1/3,
Uh-huh.
but prior to that,
No,
was
no,
there
no,
any
no
telephonic
information. As per
communication?
the FIR, no communication was given, Your Lordship.
We see reveal only CD only.
And the wife, what is the special ground, Your Lordship? The wife, Your Lordship, she has undergone surgery on 23rd of September. And the petitioner, the accused father is also not there. And his son is 3 years old.
Okay, we are trying to give a short date. From where it has to come? From Tinsukia.
He's in custody for, means for no reason, Your Lordship, because. already
That
a
is
civil-
your case, but the case is from the FIR itself. It is seen that there were not only
And in the
the
forward,
arms were also fired or it was used.
3rd of April.
3rd of April.
one more thing, Your Lordship, in forwarding report, page number 60, if that can be taken into consideration, Your Lordship, with reference to the, it's a forwarding report of the IO, with reference to the subject cited above, I have the honor to forward here with the below noted arrested accused person who has been arrested in connection with the above reference, with a prayer to remand him in judicial custody for 14 days, Your Lordship. That 14 days has already been elapsed, Your Lordship. Taking into that into consideration, Your Lordship, and
No, that is the there.
and also the special ground that the wife is under
Okay, we are
treatment,
trying
Your
to give a
Lordship.
short date. Okay.
3rd of April also.
Your Lordship, 3rd of April will be too long, Your Lordship. His wife is bedridden, that is why, Your Lordship.
কিন্তু আগতে ইমান ডেটেই নাই কি কৰিব
It's difficult.
We are very
My humble submission is, Your Lordship, he can be enlarged on bail, Your Lordship, because
Let it be on Lordship 1st of April, we'll try Lordship.
Lordship, it will be too long, Your Lordship. That's what, it will be too long.
1st of April. 1st of April, today is 17th. 26, 27 can it be otherwise?
Try Lordship. 28 Lordship.
27 is a holiday? 27? 27 trip.
Deeply obliged, Lordship.
Item 9.
May I please, your lordship? My lord, this is a pre-arrest bail application, my lord. The FIR is on page 14, my lord. My lord, basically the allegation is that, my lord, selling of beef, my lord. Assam Cattle Preservation Act, my lord. And in connection with this case, my lord, the person from whom the beef has been recovered, he was enlarged on bail, my lord. And I am the petitioner before your lordship that one allegation made by the co-accused, the person who is arrested, that he is running this business with the present petitioner, my lord. Only that much of allegation in the FIR, my lord. And in the forwarding, my lord, nothing has been speak about the present petitioner, my lord. Forwarding at page 16. And the person who was arrested, my lord, he was enlarged on bail by the learned session judge Kokrajar, my lord. On my lord 6/2025, my lord. My humble submission before the lordship, my lord, I may be allowed to appear before the investigating officer. My humble understanding is that no, my lord, custodial intervention is necessary in this present case, my lord.
So since how long you are dealing with the business of selling beef?
My lord, this is the allegation, my lord, but in the FIR also, my lord, if you FIR is page 14, my lord. Only the allegation is that পদকীয় আন পদকীয়ৰ লগত বহু দিনৰ পৰা গৰু হত্যা কৰি গৰুৰ মাংস বিক্ৰী কৰা ব্যৱসায় চলাই আছে. That has been, the allegation has been made by the accused, co-accused, my lord. And nothing has been said in the forwarding also that the present petitioner is involved in the
No,
said business, my lord.
in FIR there are two accused
My lord.
name.
Yes, my lord.
And you are not the out of two, you are not the one.
Yes, my lord. My name is there, my lord.
You are also an
number
FIR
two.
named accused.
Yes,
Number
number
2. Accused number 2. Number 1 accused was arrested, Lordship.
My lord, he is already enlarged on bail.
You are going to pay.
I will appear, my lord.
Yes, Sharma, anything?
Lordship, I will only pray for the CD, Lordship.
My lord, my humble submission is that before a lordship, my lord, that offense is below 7 years, my lord. And whether my custodial intervention is at all necessary, my lord. I will appear, my lord. If CD speaks about the involvement of the present petitioner, my lord, then my lord. My lord, my age is 66 years old, my lord, the present petitioner, my lord.
See, we are doing these things. Who lost the FIR in fact?
My lord,
Police.
police, my lord.
Heard Mr. DJ Halloy, the learned counsel for the petitioner, and also heard Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent. Back in Lihibo, this is an application on section so and so in connection with so and so, seeking so and so. Mr. Halloy, the learned counsel for the petitioner, submitted that the false and concocted allegation has been brought against the present petitioner. And more so in the forwarding report of the other co-accused, who was arrested in connection with this case, did not utter anything against the present accused petitioner. First off, the arrested co-accused persons he is already released on bail. First off, however, this present petitioner is also ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of interim pre-arrest bail. Next part, in this context, Mr. Sharma, the learned additional PP, submitted that the CD will be required to know the actual fact of the case. That considering this submission query around DD, okay, you will be under pre-arrest, under interim protection. Within 7 days, you appear before the learned trial.
Highly obliged.
Please.
Photo April.
Highly obliged.
I can tell.
Please, Lordship.
Yes.
My lord, allegation under 21B and device exception. My lord, whole allegation is against the pillion rider, Lordship, who sought leave from me, Lordship.
Your petitioner was a pillion rider.
No, I am the rider of the bike and the alleged contraband recovered from the pillion rider, Lordship. And that pillion rider sought leave from me while I was moving, Lordship, showing some emergency, Lordship. I have stated in paragraph 5, Lordship. And recovery was also made from the pillion rider, and he was arrested. And the forwarding report also says that all allegation against the pillion rider, Lordship. Forwarding report I have annexed, Lordship.
No, it's okay, as it is a case of NDPS. Let us call for the case diary when
Let the case diary come. Looks.
I have no involvement.
Photo April. Looks.
Lordship, before 1st April, any date, Lordship.
Possible. Looks.
possible may not be possible because some are in custody. They are also praying before Eid.
That's true, Lordship.
So you are still now you are not in custody. So let us see on 4th of April we see. See the call for 4th of April.
Obliged.
11.
In this matter, my lord, I'm praying for adjournment for the time being, my lord.
For the time being.
For the time being.
12.
Yes,
Lordship, it's a pre-arrest bail, Lordship.
yes.
Lordship, FIR on page number 10.
10.
Lordship, may I read?
Mm.
With due respect, I would like to inform you that my granddaughter, Miss Samina Khatun, age 13 years 4 months, is currently studying in Khaltara High School in class 9. On 24/9/2024 in morning at about 6 a.m., while my granddaughter proceeded to school from home, the below named accused number 1 with the assisted with the below named accused number 2 alerted granddaughter and kidnapped her. The accused number 1 and 2, after kidnapping my granddaughter, handed over her to the below named accused number 9, accused number 3 and 4, and sent her for sale to the accused number 5. That is the granddaughter. That is the daughter of accused number 1, staying in Rajasthan. And the accused number 5 then sold my granddaughter to the owner of the mobile number so and so at Rajasthan. Regarding the entire incident, my granddaughter intimated us for the said mobile number.
Oxo is there also.
Oxo is there.
Steps and.
issue notice কৰি দিব পক্সো আছে to respondent number 2 through registered through jurisdictional police station routed to the office of the registry and the public prosecutor. No formal notice is required to be served on respondent number 1 as the learned additional PP has already entered into appearance. Full stop. However, copy of the petition may be served during the course of the day. Also call for the case diary. We call for the case diary list accordingly after 2 weeks. Since when he is in, say AB, na? AB. After 2 weeks. You take steps today itself for sending the issue notice to the office.
Okay.
2 weeks.
Should I call the bill reading first?
Yes, bill hearing. Motion orderly motion there.
Case 152, where I has been confirmed. We have never received the ID.
Okay. And
Now bill reading.
okay, I take bill hearing.
For bill hearing, item 24.
24 also, my lord, I'm praying, madam, maybe
Time
for the
being.
timing.
Time being.
Actually, no.
25.
What is the position? Sharma? CD receipt.
Yesterday received, my lord.
Uh,
25 and 26, my lord. The petitioners are same, my lord.
but the FIR are different? Different FIR or same
No,
FIR?
the different of one is my lord, Sonari PS case, my lord. And other one is my lord, Namtola PS, my lord.
Acha. Or the same,
Same
na?
same case, my lord.
So the petitioner side is still now absent. Most probably they thought that it may come later on.
So another thing, my lord, this is my lord related to my lord, Alpha case, my lord, because unlawful activities prevention case, my lord. There are some incriminating material, my lord, since my lord, a live streaming is going on, my lord. So I not openly disclose, my lord, what are the materials for, my lord. So my lord,
Should
I have flagged back, my lord, relevant portion, lordship may kindly go through them. What are the
order,
materials?
otherwise we can.
Lordship, kindly the matter may be taken up after some time.
At 2 PM, my lord.
Lordship.
Okay. No, what is your prayer? Live streaming should not be there.
This live streaming is going on, my lord.
Huh.
That I cannot, my lord, disclose. There are something, my lord. This is very, my lord.
Live stream time যেটা হবে বন্ধ করে দিব। We'll switch off the live stream.
26.
25, 26.
Yes, 25, 26.
27.
In this case, my lord. Kindly see the FIR, my lord. Page 12.
Page
12.
Is there not received, my lord?
My lord, in this case, my lord, the co-accused bail application which was disposed on 6/3, that is, my lord, the next in this record. For
we
record,
don't know about co-accused, but the question is that he is the
LCR
FIR.
my lord, LCR is there, my lord, with the
Huh?
file. LCR is tagged with the file.
You have not received the LCR or what?
LCR is tagged, my lord.
LCR there.
Yes.
Then what you're
My
not,
lord, it is not mentioned, my lord.
Uh,
Document kindly-
27.
27 years. 27 LCR has not been shown in the cause this, my lord.
oh, acha.
My lord.
Not in the cause list, but he is saying that one BA was there 329,
Yes.
So here that is disposed of, my lord.
Yeah.
Disposed of.
wherein the LCR was tagged with.
Tagged.
And when it was disposed of?
6/3,
6/3.
3, this month.
Then you can go through or
I'll go to my lord later, day after tomorrow. my lord.
day after tomorrow. Day after tomorrow is what the tarikh?
19.
19. List on 19. Good. Okay, list in 19.
28.
28, my lord, matter may fixed on next week, my lord.
28.
20.
And a request made by the learned counsel for so and so. Let the matter be. You want any fixed date here?
No, my lord, next week.
Next week. Next week. We do. List after 1 week. But here we have received the LCR. I think LCR has received.
Yes, that's I received, my lord.
After 1 week. we will.
13.
Party.
39 definitely. In 30 also, we have received the case diary.
Yes, there is, my lord.
Third case diary received. Petitioner side is not available, may not be in a position. G Chaudhary and Kalita is there. Arindam Borwa. None appears on call for the petitioner. It is submitted by Mr. Borwa, the learned additional PP that CD has already been received. Should we receive, retain the case diary till next date?
Item number 30, my lord, we can retain it, my lord.
We cannot, we can retain.
Yeah.
Okay,
Maybe Friday, my lord, then.
Friday.
Friday.
Friday is which day?
21st.
21st, list on 21st, CDB detained till next date of listing.
Thirty-one.
31 starts is submitted, my lord.
31, no? It's a, what kind of case, this one?
This is arms act, my lord.
Huh?
Arms act.
Arms. 35 liquor. Oh, sorry, 31. None appears on call for the petition. However, it is submitted by Mr. R.G. Borwa, the learned additional PP. That case has already been charge sheeted. Wide CS number, yes.
Case number, my lord, 12/2025,
12 public
dated
2025,
28 to 2025.
28 to 2025. In view of this, the present petition is hereby disposed of with a direction to the petitioner. With a direction to the petitioner to approach the learned trial court below with a appropriate application for regular bail, which may be considered in accordance with law. With the above observation, the IS stands disposed of. The petition stands disposed.
32.
Wait, please, your lordship, regular bail application, your lord.
32 have received the case diary.
Yes, yes, there is.
Lordship, FIR is page number 10. Page number 10, your lordship. This is to inform you that today on 7 to 25 at 5:36 PM, a reliable information was received from a search by OC Sonapur PS that a person Yar Ali, who is selling narcotic drugs in the house as well as the shop from last few days, and OC Sonapur PS have been assigned to me for conducting search and other necessary formalities under section 42 NDPS Act against the person, and SI Dipjuti Nath, UBC, Izarul Ali. Accordingly, a general diary entry was made by Sonapur PS so and so dated XONS NDPS Act as per authorization given by OC Sonapur PS self along with ASI Dipjuti Nath, UBC Izarul Ali, WPC Porismita Borwa, and LNK Sorot Monikyo staff with departmental vehicle rushed to the destination along with investigation kit, digital weight machine, and seal belonging to Sonapur PS proceed to Kopalkata. Accordingly, I, along with staff, arrived at Kopalkata and conducted a search operation in the house of Yar Ali, son of late Saddaq Ali and village so and so, your lordship, and his shop in presence of witnesses. Before search the house and shop of Yar Ali, and below mentioned witnesses were found in front of his shop, and I requested them to the witnesses of the search operation conducted his house and over the person and his shop, and they agreed to the witnesses number 1 and 2, so and so, your lordship. I identified myself before the apprehended person, namely Yar Ali, and asked him about the requirements of his body search by gazetted officer, but he denied and allowed me to search his body as well as house of his shop. During search the house of the Yar Ali, and the following items were recovered by me from his house and seized from his possession in presence of above mentioned witnesses as per authorization by OC Sonapur PS. Suspected ganja, net weight 1.178 kg. Your Lordship, 1 kg and something is recovered, but I am not a FIRM accused person, Your Lordship. My name is Nazrul Ali Seth, and here mentioned the ER Ali. And I am completely innocent in this case and falsely implicated, Your Lordship, in this case. 1 kg only, Your Lordship. 1 kg something, Your Lordship. 1.178 only. From 20 kg commercial quantity, serial number 55 of the serial quantity.
Since when you were in custody?
Since 27 to 25, today is 18 days.
Lordship, but I am completely falsely implicated in this case. I am not a FIRM accused person. I am the local person in this case, Your Lordship. Only one is
Yes,
something.
yes, what is there in I?
Yes, my lord, from the case that it initially one R Mohammed was my lord arrested from his possession 1.178 my lord kg of ganja was recovered, and thereafter on the basis of his statement, my lord, he is the present my lord petitioner is the person who supplied all these my lord ganja to the my lord earlier arrested accused person for selling my lord. And so on the basis of his statement, the present petitioner was later on arrested on 27 to 25, my lord. And now my lord, investigation is going on because he is the main supplier, my lord. On being supplied by the present petitioner, my lord, initially one R Mohammed was earlier arrested, and now thereafter on 27 to the present petitioner was arrested, and today is only 18 days. Now investigation is still going on, my lord.
Only
Regarding
one
his
kg and
involvement in
something ganja, Your Lordship.
supplying all these ganjas.
Otherwise, cases registered under 21B.
Yes, ma'am. 20B2.
Oh, sorry, 20B.
Yes.
But the quantity is, Your Lordship, 1 kg and only something, Your Lordship, 170, not so much
Quantity
high.
1.178 kg, that is from the first accused, my lord, from whose possession those
And I am not
ganjas
a
were recovered, but he is the
FIRM
supplier on the basis of his
not
statement,
a
my lord.
supplier, Your
So, my
Lordship.
lord, investigation is going on regarding my lord, how he is involved in supplying all these ganja. Later on, maybe some other materials also may be possible, my lord, come out, because he is the
No,
supplier,
Your
my lord,
Lordship.
the present petitioner.
No any articles recovered from me, Your Lordship. I am not involved in this case, Your Lordship. And according to the Tufan Singh judgment, the statement of the co-accused is not, Your Lordship, believable in any cases, Your Lordship.
Okay. Hard MS immediately learned counsel for the petition, and also had Mr. P. Botapu, the learned additional PP, appear on behalf of state respondent. This is an application under section so and so in connection with so and so. Next para, it is submitted by, oh no, CD received, bills received, hard received. It is submitted by MS Medi that the present accused petitioner is innocent and he is no way connected in the arrest offense. Nothing has been seized from the person of the present accused petitioner. And he got arrested in connection with this case only on the basis of the statement made by the co-accused, which is not or even admissible in the eye of law. Accordingly, she submitted that, further she submitted that the quantity of the recovery from of the alleged contraband is also only 1 kg.
117 gram.
1 kg, 1.178 kgs, which is almost, equivalent to the small quantity. She further submitted that the accused petitioner is behind the bar since 27 to 2025, and thus the IO got sufficient time for his custodial interrogation. Next para, Mr. Botaku, the learned additional PP, submitted in this regard that it is a fact that the petition, the contraband was recovered from the possession of the co-accused 1 year early, but from the materials available in the case diary, it is seen that the present petitioner is the main supplier who used to supply the contraband to the present accused petition to the FIM accused as well as the others, and the investigation is still under process, and hence at this stage he raised objection and submitted that this is not at all a fit case to allow the accused petitioner to go on bail at this stage. So you are raising objection.
Yes, well, because he is the, from the, investor, we believe that he is the supplier. Maybe, some other materials also later on come, only 18 days,
No.
He further submitted that, he is behind the bar only for 18 days. And investigation is still under process. And hence some other materials may come out during the investigation. Next, para. Considering the entire submission made by learned counsel for both sides and on address available in the case diary, I find that further custodial interrogation may be necessary to unearth some more facts of the case, though nothing has some facts of the case, and accordingly, I do not find it justified to allow the accused to go on bail at this stage, and hence the same stands rejected. Your petition stands rejected.
Lordship, kindly give me one chance, your lordship.
Petition stands rejected. How can I give one chance?
Lordship, I am the local person, your lordship, and I am not a fair and accused person. According to the Tufansing judgment, your lordship.
We know what Tufansing says.
Yes, your lordship. So, your lordship, kindly go me allow on bail, your lordship. I am the.
Now, see, I have passed the order. Please don't argue this. This is not proper, in fact.
And
This is not proper. I have already, passed the order, so it's not proper.
I will be wait for the sometime, your lordship. If
It's already
after
rejected.
report.
You are at liberty to approach after some week also. Maybe there may be a case for you. In that case, because investigation is still under very nascent stage, in that time, there may be sufficient progress of the investigation also. You can, even if you can come after 1 week also, it's okay. Okay.
33 and 34.
33 and 34 may kindly be taken.
That.
That two, madam.
Two, there are already 3 matters have been fixed. Your matter, 1 matter is already there. 2 or 3 matters. Oh. Acha. In item number 33 and 34. Then. At 2, I don't know, it may be a fix at 2, but there are some matters. 3 matters are already there.
Okay, maybe
We can keep it as timing otherwise.
maybe fix tomorrow, Lordship.
Tomorrow, I don't know how the list is big or small, I don't know.
Day after tomorrow.
Day after tomorrow, then lordship.
Day after
So
tomorrow.
is a hearing day also. Day after tomorrow? Okay, day after tomorrow. In 19th? Okay,
19, Lordship.
19th. Both the matters, we are listing it on 19th.
God bless you.
35.
As paid by the learned counsel for the learned additional PP. Yeah.
That please, your lordship.
Yes.
This is regular bail application, lordship. FIR will file, lordship, page number 11, lordship. Translated copy, and operating person, lordship, start from page number 12. May I read, lordship? The petitioner is a businessman, lordship, and the informant is a lady, lordship, and 33 years old lady. And she is a mother of 2 child, lordship. And petitioner also a father of 2 child, lordship. And apparently, lordship, as per the FIR, lordship, some allegation is brought against him. And page number 12, lordship, may I read, lordship? I have 11 from lordship. It is due respect. It is back to state that on 16/2/2025, accused number 1 has viral my naked photo, video in the social media. It is mentioned herein that a few days ago, the accused number 1 threatening me along with my husband and son to kill them by life. The accused person forcefully prohibited physical relationship with me against my will. The accused person captured some photos of physical relation in his mobile and lordship.
We have received the case diary, my lord. As per the victim statement, my lord, her age is, my lord, about 27 years old, my lord. And my lord, the accused person is the, my lord, friend of her husband, my lord. And my lord, she has stated, my lord, that there are some, my lord, friendship between them, my lord. So they used to call, my lord, video call, my lord. And video call, my lord, the accused person asked her to, my lord, take off her clothes. Then he took some screen photographs, my lord. And my lord, that he is viral, but regarding my lord case diary, but there is no evidence that, my lord, it was viral. Because he has destroyed the entire mobile phone, my lord.
Destroyed?
Destroyed the mobile phone, my lord.
His mobile phone was destroyed.
Destroyed, my lord. And my lord, regarding physical, my lord, he has accused has stated, my lord, that he has done physical, my lord, but that is not forceful, my lord. The witnesses also, my lord, not certain anything, my lord.
Even the person.
Lordship may also peruse the statement of the witness.
The file was after 14 days since the date of occurrence, Lordship.
Heard Mr. F. Falk, the learned counsel for the petition. And also heard Mr. R.J. Bolga, the learned additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with. Since when your petitioner is in custody?
And took over Lordship, but 2/3/2025.
City receipt, perused the same hardwood side. Next, right, it is submitted by Mr. Hawk, the learned counsel for the petitioner, that he is innocent and he has not committed any such offense as alleged in the FIR. However, it is a fact that the accused, the informant used to come to the grocery shop of the accused to purchase some household items, and sometimes she also used to take some grocery items on credit. Subsequently, they developed a relationship, and she also used to call her through her mobile phone, and subsequently, by capturing some nude photographs, she started blackmailing the present petitioner, stating that she will make viral those photos if he does not give her 6 lakhs rupees. After the said incident, his wife also lodged an FIR which has already been registered. An investigation is still under process. Mr. Hawk further submitted that only to blackmail and to extract money from the present petitioner, she lodged the FIR with some false and concocted stories. He is behind the bar since last 2/3/2025 and cooperated the IO in the investigation of this case. However, he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with bail. Next para. Mr. Borwa, the learned additional PP submitted in this regard that from the materials available in the case diary, that is from the statement of the victim as well as the other witnesses, it is seen that there is no evidence or allegation of making viral these photographs, except some threatening on the part of the present petition. He further submitted that there was a allegation of there was a physical relationship with the victim along with the present petitioner, but from the matrix, it seems that there is no allegation of any forceful sexual relationship. Rather, it seems to be consensual. Next paragraph, considering the interest submission made by learned counsel for both sides, materials available in the case diary, I find that further custodial interrogation of the present accused petitioner may not be required for the interest of the investigation. DD Bhattacharya. Where it is pending?
CGM Nogam.
CGM now.
Judicial Magistrate Nogam.
Okay, it will
Deeply obliged.
granted with bail.
Deeply obliged. Obliged.
May I please, your lordship? Madam, I was there in item number 31, which is a bail application, 33, 30, my lord. The CD is also here, my lord. I could not be there on time. If the lordship kindly permits to take.
They're
up the matter,
already heading.
I know, my lord, but then, my lord, this-
21-3.
I know, my lord, this late man along with his wife, my lord, is in custody since 47 days.
21.
And a minor
We
child is
hear it
outside,
at
my lord.
21. 21 is Monday. Friday. Next Friday, we are fixing it.
On 21,
Yes,
my lord.
20. Yes.
Okay.
53 of the supplementary list.
No, it will go. What's it say? 53.
Service completed, my lord, on the last equation, amicus was appointed.
Excuse me. It will propose 52. I'm making an affidavit of task, no? 52. 52. Affidavit. 53, yes.
My lord, on the last equation, amicus was appointed, my lord, service
Acha,
was
acha.
completed. None appeared for a petition.
Can appears on call for the, otherwise we have received this scan copy.
Can go be received, my lord.
It's a POXO, I think.
POXO, my lord.
Heard, no, none appears on call for the petition. Heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. And also heard MS B. Chaudhary. B. Chaudhary, the learned amicus curiae, appear appointed on behalf of the respondent number 2. Appeared on behalf of respondent number 2. Scan copy of the case record has already been received. List the matter accordingly after 1 week. We're not going to fix any date after 1.
37.
37 case diary is.
Various bail application, my lord.
Take a break at 2. Huh?
The whether service is completed on my lord, this is.
Oh.
It's the process of law.
On the last occasion, the order was there on the said date. And the officer in charge of the Hazo police station shall apprise the court regarding the service of notice on respond number 2. Let us see the service report has received from the officer in charge police station. Service report is there, I think. Otherwise, services seems to be completed.
Yeah, but amicus may be appointed.
Heard Mr. You are Mr. J. Ahmed. Heard Mr. J. Ahmed, the learned counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. Respondent from the office note dated 10/3/2025. It is seen that the service is completed on respond number 2, but none appeared on her behalf. Later amicus नाम to DDO का कलर नाम to DDO. Registry. Let an amicus be appointed to represent the respond number 2. Registry will do the needful list. Otherwise, we have received here the any what kind of thing? We need a scan copy or a
Case that is.
case diary?
Case diary.
CD retained.
We didn't, that will be,
Okay.
that will be
When
next week, next Monday.
next Monday?
Monday.
Next Monday will be 24th. 24 corridor next Monday. Till then, CD be retained. So we are fixing it on 24th. Will amicus appointed and the matter may be heard. We are retaining the case diary.
My lord.
Obliged.
39.
May it please the lordship. For anticipated bail application, case there is perhaps available, madam. Case there received, madam. And this is a case where pertaining to recovery of 3.75 grams of heroin from our house. We are husband and wife, madam. From our house, 3.75 grams of heroin was recovered, and the case has been registered under section 21A and 29 of the NDPS Act, along with sections 111 and 123 of the BNS. Now, your lordship will find the FIR at page 11. Page 11, madam, and has it. There is a long FIR, but basically first paragraph, it says that this is to inform you that reliable information was received from a source by OC Rupoya PS Nagaon, Assam, that at 4:30 PM on 24 December 2024, as per information, one person named Fazaluddin. Fazaluddin is the petitioner number 1, along with his wife, had been selling and dealing with huge quantity of narcotic substance at so and so place. Now, my lord, will kindly come to the next page, my lord. Page 12, second paragraph, my lord. They recovered 30 so and so number of plastic vials containing suspected heroin as weighed by government digital machine, and found 44.96 grams with plastic vials and 3.75 grams without plastic vials. So the weight of the contraband, my lord, is 3.75 grams, which is a small quantity. So, my lord, this honorable court has already decided the issue as to whether, because there was some issue as to whether 21A is bailable or not, my lord. So by recent judgment, this honorable court has already held the 21A is a bailable offence, my lord. Lordship will kindly come to page 8, para 22. All the judgments, my lord, from Bombay High Court and as well as the statute itself, my lord, has been discussed in para 22, page 8. It has been held that for the reasons discussed in foregoing paragraphs, this court is of the considered view that the offence under section 21A of the NDPS Act is bailable offence, and this court fully agrees with the observation made by the coordinate bench of this court in the case of Amir Ali versus State of Assam. So there was another case wherein also it was held that this was bailable.
You are basically relying on the section is bailable.
21A is bailable.
Now, see, question is that if you're relying on this,
Yes.
then I must say that you just submit it before any other bench without me, because my view may be a bit different, because I found that the act itself says that it's a non-bailable. So till now, is there any Supreme Court?
Supreme Court judgment is not there.
It's
Other
not
high
there.
courts are there.
Either high courts are
Yes.
there, I know. Well, I was dealing with
ma'am.
the cases in as a district judge also, I
My lord.
found. The other high courts there, but coordinate bench of this court was very few numbers of one case was there, wherein it was considered in other way, not
ma'am.
as a bailable, but other way.
Right.
But this I have seen that most
This
probably he has
specifically, yes.
considered specifically it's a bailable one. But my view may be different. That's why I think that it should be. Then how we order will be there? We pass the order.
Otherwise, my lord, section 111(1) organized crime is also there. My lord, that is
Yes.
a non-bailable offence, my lord.
No, whatever, but he is
Yes,
basically
yes, ma'am, yes.
stretching on that point.
Ma'am.
So how the order will pass down? Can I get him the order?
List before any other bench.
How can? We just simply said a list after 1 week will do.
This
Then
bench is
what to
there,
do?
my lord, so it will again come perhaps before this bench. Special, because your lordship is taking up special acts even on the next week, my lord.
Yes, most probably.
Yes, ma'am, as per the roster. This before any other bench, perhaps. my lord.
Two bench we are taking most probably and special
Special act.
NDPS.
Yes, ma'am.
Court number 3 is
Court
also
number three is
taking.
also
Can I get it? Not be a problem.
So, my lord, may say list after 1 week, my lord.
Then again it may come. That is one problem.
Before any other bench. my lord.
The list before any other
Right.
bench will, after a week,
After which,
list before any other bench after a week.
date my lord, otherwise we have to mention this case for it to get listed, my lord. Pending for a while, my lord. Next week, my lord,
You want the date fixed?
24th, my lord.
24. Okay, 24.
I'm deeply aware.
40.
My lord, is the pre-arrest bail application, my lord.
Yes.
But may I invite lordship attention to the FIR. The short FIR page number 10, my lord. This was lodged on 4/2/2025.
Yes.
My lord, what happened in this case? The present petitioner, he is not acquainted with the main accused person who is already arrested. Now, both of them are from Meghalaya. Now, one day, the main accused person who is already in the jail collected the phone number of the present petitioner and offered him a bike to purchase the bike. My petitioner said, I don't have the money. So the accused person requested me that if you know any person in the locality who is willing to purchase. So the petitioner here introduced one of his friends. That if you want to purchase the bike, you can purchase it. So the bike was delivered to that gentleman, the third person who has purchased the bike. Now deliver the bike, and thereafter, my lord, the police has issued a notice to me on 25th of February, recording his statement. And I said I'm not the purchaser. I'm not aware of aware that the bike is a stolen bike. Yes. So I appeared before the IO, gave a statement. So IO recorded my statement and requested me to cooperate with the investigation to recover the bike. I said, yes, the bike is with my friend in Meghalaya. I will ensure that that will be delivered. So he went back to Meghalaya and approached his friend, along with his friend, delivered the bike to the Nongstoin police station on 27th February. The bike is lying before the police station in Nongstoin. Thereafter, my lord, the police again asked me to appear on, in fact, 3rd March. My father, my lord, the petitioner did not able to speak English or Hindi or even the Assamese. He only speaks the peculiar local dialect. So his father used to accompany him. On that day, his father was not keeping well. So on 11, they appeared for the IO again. Give a statement.
11-3.
11-3. My lord. And now they asked me again to appear on 21st. That is coming Friday. 20. I stand corrected. On 20. So in fact, my lord, Mahapas submitted, he is cooperating with the investigating officer. My lord, if he is arrested, my lord, no one is said to interpret his statement also. Therefore, his father always accompanied with him. His father, along with the accused person, is cooperating with the police. So since I cooperating with the investigating officer, Lord may kindly give me some protection. Pre-arrest will be granted to me, so that I will continue to cooperate with the IO. Three times I would be appeared.
Anyway,
We have received the case diary, my lord. Although my latest senior friend has submitted that, my lord, he has initially he has cooperated with an investigating authority, my lord. And he has also, my lord, helped the investigating officer to trace out the bike, my lord. But there is no such statement of the, my lord, this accused petitioner, my lord. So my humble submission, my lord, let him appear before the IO, my lord. And we'll call for the up-to-date case diary, my lord, after his appearance. Because since there is no statement, my lord, so that, my lord, I cannot say, my lord, whether he has, my lord, his statement is recorded or, my lord, he have helped to really to trace out the bike.
In my petition also, I make a categorical statement, and come 20 also, I'm ready to appear. So lordship will give me protection.
your name is HL.
Shangri-So.
So
Only, my lord, his submission may be recorded, my lord. that
yes,
he
yes,
has-
obvious. And also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of state respondent. This is an application and section so and so in connection with so and so. Mr. So and so submitted that the present petitioner is innocent, and he only helped one of his friends to purchase a bike without having any knowledge that the said bike was a stolen one. However, he cooperated. He accordingly he received a notice from the IO, and he cooperated him in the investigation. His statement was also recorded accordingly, and he helped the IO in tracing out the bike and which was which could be traced out on 27/2/2025 from Meghalaya, and presently the bike is lying in the concerned police station. Further, he submitted that again he received one notice on to appear, asking him to appear before IO on 3/3/2025. However, due to some personal inconvenience, he could not appear on 3/3/2025, and subsequently he appeared before the IO on 11/3/2025, and accompanying with his father, as he is not acquainted with any English, Assamese, or Hindi language. Full stop. He further submitted that he again received a notice asking him to appear on 20/03/2025, and accordingly he prayed that some interim protection may be provided to him so that he can appear before the IO and can cooperate in the investigation of this case. Next para, Mr. Burwa, the learned edition PP, submitted in this regard that there is no such statement made by the IO in the case diary, though he stated that he had already cooperated the IO and even assisted the investigating officer to tracing out the bike. Accordingly, Mr. Burwa submitted that one chance may be given to the present petitioner to make his statement before the IO. Consider reply. Okay, you will be granted with some interim protection. We are calling for the updated case diary. Appear before the IO and cooperate, and let your statement be recorded, because as the statement which you have submitted before this court that you have cooperated and a bike was recovered, this kind of submission statement is not available in the case diary. Otherwise, it may be a case for anticipatory bail also. So appear, some interim protection will be there, appear before the IO and cooperate in the investigation.
That will come on 10th of April.
Yes. You're fixing it on 10th of April, within 7 days, you appear before the IO.
Deeply obliged.
Of video that the accused number 1, along with other accused, with the intention to kill my husband, were hitting him in his body with a rod inside a house and kept him concealed somewhere. We saw in a mobile mind. Then that being so in position to search about the whereabouts of husband, the delay in filing the FIR. Now your lordship kindly see, this is 25/9/24 missing my. Your lordship kindly. Then my your lordship kindly see FIR was lodged on 4/11/24. And this person, my lord, he has made an appearance before a court in connection with another case on, your lordship will find, yes, appearance. We'll cover the whole plan. Page 80, 17, 18, 19, my friends. 18 and 19. Victim is my lord, he is no Kamal, my your lordship got the name, my. And he has given appearance on 4/10/24 in connection with the case before the South Salmaga model. Your lordship got the problem. That is 1/10/24. Type copy is page 17.
Before special judge,
Before
South Salmaga.
South Salmaga, especially South Salmaga, Mankachar. Then he appeared in connection with another minor in this case. Page 20, page 20. 8/11/24, he was He's seen here, he was produced before the court and his statement was recorded. The recovery documents. Sir. On this ground, all the named accused came before this honorable court. Now, on payroll to the city, his interim was there, subsequently made as page 15 or 15. Page 15. All the named accused. On this ground, my lord, they are initially they are granted interim, subsequently it was made absolute after we absolute. Now, the present petitioner, because he is the family members of those persons, he is not named. But because they got bail, now again police is after him. On the same ground.
Yes, Potter.
Otherwise, my lord, from the order dated 8/11/24, it reflects that yes, victim no Khandakar appeared and my lord, regarding victim no Kalam Khandakar appeared before the court. But here from the FIR, it reflects that allegation is that my lord, my husband Nur Kalam were hitting him inside his body with a rod inside the house and kept concealed inside the house. That is the my lord incident of on 28/10/24.
Yeah.
So that incident cannot be impossible because only because 8/11/24 he appeared before the court and his statement recorded. But that cannot, my lord, nullifies the my lord offense that was committed on 28/10/24.
Missing
But
25
the
now.
allegation is that he is missing since 25/9.
Nine.
And one video footage or videograph was shown on 28/10 that he was
28/10.
hitting iron and kept in a
FIR
room.
was on 4/11.
But if you go by the order of the Special Judge Sar Salmara,
Yes.
then he appears before the Special Judge Sar Salmara on 4/10.
4/10.
So
Well,
which is
110,
within,
it is 110, right? 110.
sorry,
110.
110.
110.
Sorry, 110.
Thereafter on 4/10 FIR lodgement.
Yeah.
Then
So after
Not-
that, I was lost.
not on the FIR was lost on 28/10.
No. 4/11.
Oh, sorry, 4/11.
4/11. After my lord that year. Only because there was something, my lord, this person has nothing to do, my lord, with this. He is neither no allegation against him, he is neither named on the FIR. And on the face of it, my lord, it is not the case of my lord that.
Let us see, let him appear before the
Yes.
trial.
Recording.
By Mr. H.R. Chaudhary, the learned senior advocate,
You know,
assisted by
it-
Mr. R.A. Chaudhary, the learned counsel for the petitioner, and also heard Mr. P. Bhattakur, the learned additional PP, appearing on behalf of state respondent. And this is an application under section so and so in connection with so and so. Next, paragraph, it is submitted by Mr. Chaudhary, the learned senior advocate, that the present accused petitioner is innocent and he is nowhere mentioned in the FIR also. However, it was when the FIR also full stop. From the FIR, it is seen that the incident of missing of from the present of the incident of missing of the husband of the informant had occurred on 25/9/2024. However, she lost the FIR only on 4/11/2024. That is more than 1 month.
40 days.
But more than 40 days, after 40 days.
40.
Further, it is submitted that on 28/10/2024, she saw a video footage wherein her husband was beaten up by the accused and he was kept inside a room. But surprisingly, on 1/10/2024, the said husband of the informant appeared before the Special Judge Sar Salmara, and his appearance was also recorded by the court. And in the same time, it is also seen that on 8/11/2024, he was recovered and his statement was also recorded by the learned magistrate. Accordingly, she submitted that with some false and concocted allegation. The present FIR has been lodged after 40 days of the alleged incident of missing. However, the present accused petitioner is ready and willing to cooperate the IO in further investigation of this case if he is granted with some interim protection in form of the interim pre-arrest bail. Next para, Mr. Botakur submitted in this regard that though there was a delay in the lodging of FIR, but it is also the case of the petitioner that her husband was kept inside a room by hitting with an iron rod. And accordingly, he insisted that to know the actual fact of the case, the CD will be called for. Next para, considering the entire submission made by the learned counsel for both sides, okay, will be granted with interim protection.
Obliged.
When it can be
From the what?
My lord, on 27th of March.
27th of March. I don't know, this one,
Yes, on April, on 23rd of April.
23rd of April. 23rd?
Yes. On 9th of April.
Okay, 9th of April. Appear before the IO within a week,
Within 7 days.
or within 7.
Time being 24.
On the 24 NDPS, my lord.
Hmm.
So this present petitioner become victim of circumstances, my lord. He is a, my lord, driver having in the old vehicle, my lord. And the vehicle which was intercepted and which was seized, that driver was known to him, my lord. And he simply, from Golpara, this present petitioner was taken because he was not feeling well. He said, "You please come and help me, and I will come tomorrow morning." Accordingly, the petitioner accompanied him. On the way, my lord, the vehicle was intercepted and found 308 grams of heroin in the vehicle. This is my case. Now you will kind of the FIR, my lord. They are saying in the FIR language that I am the co-driver. One driver is one Shahjahan, and I am the co-driver. I was available in the vehicle, and main culprit is one Sanwar Hussain. Ultimately, they led, and ultimately he was also apprehended. Now all the 3 persons were apprehended, my lord. Now page 16 is the FIR. And today, 137 days he is in custody, my lord. 137 days. 137. Arrested on 31st 10/24. 31st. Yeah. Now you always kindly say page 16. That source information received by Kulinang part of Kambo that notorious narcotic that Sanwar Hussain. I am not Sanwar Hussain, my lord. Sanwar Hussain of Golpara, who was staying at rented premises at Garigaon, Guwahati, and ordered a consignment of narcotics from Manipur, and that would be transported from Guwahati to Golpara in a white Bolero bearing registered number so and so. This car does not belong to me, it belongs to some other person. Now, based on 8:15 p.m., the vehicle was intercepted in front of Polashbury PS, and the 2 carriers were found. Shahjahan Ali was driving, while Rosali, present petitioner, was the co-driver. At the back side seat, one suitcase was found and searched. Inside 2 blankets were found, and inside the blanket 25 soap boxes containing 25 packets of 308 gram without soap box. The narcotic also seized and both accused were apprehended. Later on, they led to the police team to the rented house of the main kingpin Sanwar Hussain at Garigaon. He was also apprehended, and one Honda number so and so has been arrested. Then it may be mentioned that accused Sanwar Hussain is a notorious drug peddler. Your lordship got it on page 10, I am reading. He is a notorious, accused Sanwar Hussain is a notorious drug peddler who has been carrying on the narcotic drugs since long.
some of the NDPS cases in which he was previously booked as under. So that I have nothing to do with Sanwar, my lord. Whole case, my lord, main person is Sanwar. I am what happened to me, my lord. I am having a vehicle. I have come for the my lord for the repairing at the workshop. Then that driver told me, my lord, he is not feeling well. He is to come over here and from over here to Golpaka he again to go. That simply accompanied my case, subject to what your worship may find that is another aspect. This is my case, my lord. I have no way, I have no knowledge about that my lord, backside, what is written, what is scraped from now, nothing, no knowledge at all, my lord. But 250 gram is commercial. Here it goes by 308 grams.
Case that he received, my lord, the commercial quantity of contraband, my lord, and
Yes.
recovery is made from both the accused persons, my lord. This Arif Hussain alias Rose Ali and another, my lord, Shahjahan Ali, my lord.
From the vehicle, no?
From the vehicle, my lord, and it was the knowledge of the, my lord, accused person, my lord. It was in the knowledge of the accused person. It is not that, my lord, the accused person does not have any knowledge, my lord. That, my lord, in the vehicle, my lord, there are some narcotic has been hidden on them. But it was in the knowledge of the both the accused person, my lord. And on the basis of, my lord, some secret information, my lord, police has arrested, my lord, as is from both the accused person, my lord. And now the case is pending to correct the accusation.
So as per the materials available in the case diary, the recovery was from both the accused person.
Procedural.
As per FIR, it is from the back side of the back seat, my lord. It was from the seat. I was sitting along with the driver in the front seat. So knowledge, what is the basis of that, my lord? That is the only question. I am not denying I was present. But only question is whether I had knowledge or not, my lord, what is the basis of that statement my learned friend made? Or FSL would he want to do?
The FSL report is pending, my lord.
But he is the petitioner is behind the bar since last 137 days.
137 days.
So we can fix a, my lord, date after at least 2 weeks, my lord. So the investigation is
If there is any basis of my knowledge, my lord, certainly, my lord, he got a case. What is the basis of making this statement, my lord? It is in the FIR itself, my lord. I was there and it was found in the back seat of the car vehicle. Car does not belong to me. I have no, if it is true that, my lord, I have accompanied him in the midway. Certainly, madam, not way that my statement may be correct. My lord. That is what I am saying. 137 days, my lord, and he is not the main culprit is one Sanwar Hussain.
Okay, then if you want to insist on
In
this,
the case, my lord, then call for the FSL report, my lord, fixing a date after at least 2 weeks. It's a, one of commercial quantity, one days of.
he'll be able to 2 weeks.
I lift your worship. But that is also, he got also 1 point, my lord, FSL, but FSL ultimately suppose it comes, my lord, narcotics.
And you want to say the recovery was not there, but as per the this seizure list, the recovery was from both the
My lord,
persons.
FIR
That
itself
is,
says, my lord, from the back seat, my lord.
no, obviously backseat, but knowledge is beyond it. Possession may
The
be
knowledge, my
constructive,
lord,
conscious, whatever.
that cannot be, my lord, at this stage, I don't know. My lord.
That is yeah,
That is
because
there.
if you say in that manner that backside is there, then the other
But
co-accused,
I
he was also sitting in the car only.
I was not the original owner, neither owner nor the driver of the vehicle. Incidentally, my lord, I was there in the vehicle. That is my case.
Assuming, my lord, that he is a passenger, my lord, and he does not have.
Passenger, I'm not saying I'm not present because he called because he was not feeling well, so he just called me. Maybe his intention may be bad, that is I do not know. But so far I am concerned, I have come, my lord, for a fight, I have might taken it.
Okay, then if you want to fix it, then prior ED you can fix, isn't it?
The 10 days.
We'll fix it on 1st of April, my lord.
First of all,
Today is 17th.
If you insist that your prior ED, then 1st of April will not do, I think, no?
Then
You what want to say?
It should not be on 1st of April.
then 28, my lord, 28.
28 corridor, so list on 28, CDB routine,
April Fool is
call for the yeah, then additional people will make communication with the IO to call for the, the report of the FSL. List accordingly on 28th video.
It is first April, it is not fixed, my lord.
No, 28th. First April fixed, then
I am
your-
already full, one. I should not become again full, my lord. April day, first April.
Okay.
Matter for admission, item 13.
Process service দুটা timing আছে যে সেইটো বেলেগ কোনবা এডভোকেট আছে No, তাতে কৈছিলে যে কোনবা এজন কলিগে আমাৰ চাই আছে বুলি আজি বড়ো was looking at that. I think it was he is here now. Then do it will be discussed. What is it? Admission letter? 1-3.
Yes, may I please lordship?
Yes.
Petitioner before lordship file the response number 2 in a criminal proceeding.
Respondent is here only?
Respondent number 2.
Yes, what you say?
Yes, lordship. I am responding in a criminal proceeding filed by the respondent 2 before the trial court additional CJM Borpeta under 138. So far the case is concerned, I issued a check of 1 lakh. Thereafter, I paid the entire amount, and there's a deed of agreement with the respondent number 2. That is in page 18, Your Honor. Deed of compromise.
Deed of compromise, yes, page 18.
Page 18, Your Honor. So during the course of the trial, I paid the entire amount. Page 19, para 1. Yeah, which is by both the party in para 1. That was the payment of the agreed amount. The second party accused has paid an amount of 1 lakh on 23 so as full and final settlement amount, and the same is acknowledged and received by the complainant first part in the presence of the witnesses. This is the agreement between the complainant with the accused, and it is also executed before the 2 witnesses along with one advocate who was there. So, and in the agreement, it is second column was there that after receiving the money, they will withdraw the proceeding. That was the condition as second. That after receiving the check amount from the second party, the first party has agreed to withdraw the NI case number so and so pending before the honorable court of so and so. This is the second condition. But after receiving the money, the complainant responded to is silent. And now, yes. So we are appearing before the court, and trial court takes to cognizance against me, lordship. Against the cognizance, I before honor that as there is an agreement between the parties, and I paid the entire amount, and it is documentary evidence.
Which is the order of challenge?
Yes, impugning order is the lordship. Yes. Page 21, and except C. Yes, the top lordship. Complaint is present, accused is, yes. On face of the case order, I found sufficient materials against the accused. Hence, offense under section 138, negotiation so were read over and explained to the accused person to which he pleaded not guilty. That is the cognizance.
But you have said that during the pendency of this case, there was a compromise, and
Yes.
the pursuant to that compromise, you have already paid the entire amount.
Yes, and it is.
But that was not brought before the trial court
Yes,
below?
yes, Lord, it is brought, lordship. It is brought as an and copy was given to them, lordship. And now they are challenging that this signature which was done by the second party, respondent 2, is a forged one. That is their contention. They filed their affidavit. In the affidavit, the total contest is that signature is not a genuine, it is forged signature that is done by me, lordship.
I want to show the
Come,
signature, my lord.
Just yes, you will come. So that is their contest is that a signature is a forged one. In the affidavit, they had explained categorically. In all the paragraphs, that is the only contention. The signature that I have prepared or posed or the agreement that I placed before now, that is a forged one. So your also lordship may come into their petition, complaint petition, which I enclose annexure 1. The signature is, your lordship can see in page 11, 11, 12, 13, 14. This is the complaint petition. This is the complaint para 14 is their affidavit. Everywhere you will get, your honor can see the signature of the respondent 2. just in, yes, place 11, 12, 13, these are their signature. And in agreement, which is can start from page 18. 18, 9, yes, 18 and 20 is the signature of the respondent too. The signature are almost same. It is maybe their intention in somewhere he has changed something in title lordship. Otherwise, signature is same. Please. So they are challenging the signature. So yes, sir. So may I pray, their only contestation is that signature forged one, it is prepared by me like that. No. But so far their document is concerned, complaint, petition and the agreement, the signature is similar. So my prayer is that if they challenge the signature, it is a forged one, it is not by him. So I am making the prayer before the court. One of the court may send the document to the forensic laboratory to find out the truth of the case, whether that is done by the respondent too or by the complainant. When they are challenging the signature also. That is my only prayer. Otherwise, so far the document records I paid the amount, though the charge payment against me may be discharged also.
My lord, if I may.
So here, as per your petition, you're challenging the order of taking cognizance, is it?
Yes, lordship.
My lord, if I may.
Yes.
My lord, first of all, my lord, I am disputing a signature, my lord. So much so that, my lord, if my lord, they compared a signature in the complaint case, my lord, very well it can be seen. And in the compromise sheet, my lord. At the end of the compromise sheet, the Rajiv Verma, what is written there, it has put a signature in the some other way around, as compared to the Rajiv Verma. Because I had given a statement in the complaint, in the affidavit that in the complaint case which I have filed is a genuine one. The signature which I put there is a genuine one. So much so that the compromise sheet is not notarized, my lord.
That is like that.
It is not notarized, my lord. It has been never notarized. That's why, my lord, the fact remains is that when it was brought to the magistrate, when magistrate saw that compromise deed, it has not taken into account. Because there was a dispute in the signature. And my lord is very well aware of the section 73 of the Evidence Act. My lord can compare the signature of the two documents when there is an admitted signature, my lord. And my humble prayer is that, my lord, if my lord may, because my lord, I'm being prejudiced, my lord, because there is an NI case going on, they have produced a fabricated document, they have forged the signature, and now they are coming up with this revision that no, this is the correct one. I have not signed the document, my lord. I have not, this is for the first time which I am looking at this document after filing the criminal revision, my lord. Well, I pray, my lord, that the criminal revision may be dismissed because this signature is fraud. My lord has the power.
Have you made any prayer before the learned trial court below for
Because it has
sending
been
the
stated, my lord.
signature?
Yes, my lord. Yes, my lord, because it has been stated by this honorable court. That's why it couldn't be proceed, my lord. Now, as a matter of fact, that my lord when very well can see, my lord, the signatures, my lord, in the
Where is it?
complaint
Where
case,
is
my
the
lord.
FR? See, show me.
My lord, in
Yep.
complaint case, my lord, my lord, may please come to the page number 13. And then, my lord, may please come to the page number 19. Or maybe 19. My lord, may please compare the signature, my lord. Not the R is matching, not the J is matching, not the last A is matching, Rajiv Verma. Absolutely forged, my lord.
All right.
Absolutely. Absolutely forged, my lord. This document was never signed by me.
When Burma BRR is also not the same, my lord. There's nothing to send out of FSL. Even if they send the FSL, my lord, let it be. But my lord has a power in the section 73 that if there is admitted position of the signature, then my lord, it compared with both the documents, my lord. A humble prayer is that this criminal revision petition may be dismissed, my lord. Because I have given the statement, my lord, that this signature has been brought to the first time in the criminal revision petition. I come to the notice in paragraph 4 of my affidavit. In paragraph 4 of the affidavit, page number 3, at last time, my lord, I have written that in this context, the respondent number 2 would like to state that there was no compromise executed between the petitioner and respondent number 2. And the said compromises came to the knowledge of the respondent number for the first time when the criminal revision petition was filed before this honorable court. After receiving the criminal revision, it came to the knowledge of the respondent number that the compromise deed was not even authorized by law, which was to show that it's a false and fabricated, and the signature there was a forged signature, my lord. In fact, my lord, page number 6, my lord, I have written the answering respondent would like to state that on the grounds taken by the petitioner is absolutely incorrect. It is submitted that a compromise is executed between the petitioner and respondent is absolutely false and fabricated, so much so that the signature of the respondent number is a forged signature as it is can be compared from the annexure 1 and annexure 2. As annexed document in criminal revision petition. The said deed is not even authorized. The respondent number would like to state on oath that signature of the complaint in annexure 1 is the correct and true, and the signature of compromise is a forged. I'm giving on the oath, my lord, that the signature in the complaint petition is the correct and the genuine signature which I have put in the complaint case, whereas the signature in the compromise deed, I have never put that signature. Pray for the dispute, my lord.
Yes, sir. May I tell he is saying leave this way. The entire sign, my price is signed by the respondent 2. Now to jump up this matter, so entire document may be sent to FSL to find out the truth. Whether I am wrong or he is wrong. That is the best personal lordship. Because I am a widow lady of this and I paid the entire amount in the presence of 2 witnesses who are the local people. Local people in the presence of 1 advocate who drafted these things. Now after taking this, they are not withdrawing. So this is the present position. I have to run before the court every day. So that is the position. If my document is false one, I am saying. So later maybe enter document we come to the FSL to find the truth, your lordship.
If that means so, my
Yes,
lord,
lordship.
my lord, if I pray, my lord, if that is something, let the magistrate send this compromise to the FSL.
Heard Mr. D. Dedi, learned counsel for the petition, and also heard you are Mr. G. Datta. You are
A.R.
Mr.
Purva.
A.R.
A.R.
Purva. And Mr. A.R. Purva, the learned counsel appearing for the respondent number 2, and also heard Mr. P. Bothakur, the learned additional PP appearing on behalf of Interim. State respondent number 1. This is an application under section so and so in connection with so and so for looking for setting aside and quashing of the order dated 16/11/2022 passed by learned JMFC in JMFC Borkata in connection with NI case number 156 of 2021 under section 138 of the NI Act, whereby the learned court below took the cognizance against the accused petitioner after finding sufficient materials against him. Next, it is submitted by Mr. Day that during the pendency of this case, both the parties entered into an agreement for compromise and in person to the said agreement for compromise he had already deposited, he already returned the entire check amount. What was the check amount of rupees 1 lakh?
1 lakh lordship.
Check amount of rupees 1 lakh, which is duly accepted by the respondent number 2. And with a condition that the matter may be settled, amicably settled outside the court. And the payment of rupees 1 lakh shall be considered as a full and final settlement amount. Full stop. He further submitted that in spite of the compromise between the parties, the learned trial court below had took cognizance against the present petitioner by order dated 16/12/2022. Sorry, 16/11/2022, and hence the same is liable to be set aside and quashed. Next para. Mr. Borwa, the learned counsel appearing for the respondent number 2, submitted in this regard that from the very initial stage, they are denying that the petitioner number 2, respondent number 2 never entered into an settlement for agreement for settlement, or nor he put any signature on any settlement agreement. Full stop. Further, it is submitted that the signature which were shown to be executed by or shown to be put by the accused by the respondent number 2 is not similar to the signature put by him in the complaint petition, which can be seen even with a bare eye. However, he submitted that the matter may be remanded back with a direction to send the signatures of the respondent number 2 for examination before the FSM. Next para, Mr. Botaku, the learned additional PP, also submitted in this regard that the petitioner has the respondent number 2 had challenged the signature of the respondent number 2 signature, which was shown to be put in the compromise petition, and accordingly he also insisted that matter may be remanded to the learned trial court below. So it's next para, hearing the submission made by learned counsel for both sides, it is seen that the document which were basically relied by the petitioner, that is the compromise agreement, is challenged by the respondent number 2, stating that he never put any signature on the settlement agreement, nor there was any settlement between the parties, and neither settlement parties, and he never received back the check amount from the accused petitioner. And thus, full stop. The learned trial court below accordingly took cognizance against the present petitioner after the order. Order of cognizance is at page
21, my lord. Last page.
Your compromise was settlement was agreement was signed on when? You are saying that during the pendency?
23rd day of June 22, lordship.
That was not produced before the.
Yes, as per instruction, that was produced. And they are also denying. After receiving the amount, they are denying. lordship.
Did you say first one? Petitioner, though it is, though the compromise agreement was produced before the learned trial court below, it is seen that full stop. Though there is no mention about the production of the said agreement, settlement agreement before the court, there, comma, the learned trial court below took cognizance against the present petitioner, finding sufficient materials against him. Full stop, next para. Thus it is seen that the main document of the compromise agreement is also under challenge, wherein the accused, wherein the respondent number 2 had challenged that he never put any signature on the compromise agreement, and it was, and on the basis of some forged and fabricated document, the petitioner tried to get an order in his favor. In view of this, I find that no irregularity or illegality has been committed by the learned trial court below, while taking cognizance against the accused petitioner under section 138 of the NI Act, wide order dated 16/11/2022. And accordingly, I do not find any reason to make any interference in the order passed by the learned trial court below. However, considering the submission made by learned counsel for both sides, I find that the learned magistrate may take, learned court below may take necessary steps for sending the FSL, sending the signature of the present respondent number 2 to compare with the question document, that is the compromise agreement, with the signature of the respondent number 2. With the above observation, the present is disposed of. Your petition stands dismissed. However, direction is given to the learned trial court below to send the signature of the respondent number 2 before FSL for examination. Item 14. Affidavit, fine, yes. Your affidavit has come out.
My lord, the affidavit we have received right now, my lord. Now we'll have to respond on that, my lord. Let the matter come up on day after tomorrow, my lord. So that we
Day
can-
after tomorrow may not be possible. We have already fixed some of the matters on day after tomorrow.
My lord.
Maybe next week.
As the lordship, please, my lord.
I think, my lord, like to point out, if your lordship sees the last order, my lord,
That tells that they're not.
21 to 25, my lord, there was a submission made by the petitioner that the maintenance amount due to the petitioner number 2 has not been paid, my lord. That's the second para of the order. But this is now accordingly the court said deposit 10% of the amount, my lord. The difficulty is this, my lord, this submission was not factually correct. First of all, petitioner number 2 is not even before your lordship. The mother and son had filed for maintenance, my lord. And the court did not award any maintenance insofar as future maintenance is concerned. It said that I need to pay maintenance until he attains majority, which he already did in the year 2020. So there is actually no question of me giving further maintenance. Order doesn't really say so. So this order perhaps would again now create confusion over it.
My lord,
So by this order, 10% was
Yes.
asked to give it.
Of the awarded amount, whereas there is no awarded amount. If your lordship sees page 45, page
Yes.
45, para 12, my lord, in view of the decisions arrived at point number 1, it is ordered that the petitioner number 1, that is the wife and the petitioner before your lordship, is not entitled to get any maintenance. On the other hand, petitioner number 2 is entitled to get monthly maintenance at the rate of rupees 7,500 per month from the answering OP from the date of filing of the petitioner for maintenance till the date of his attaining majority That is on 24/6/2020. Now the order itself was passed on 30/6/2023.
Oh,
And now, my lord, I have already been paying maintenance in excess because this order came in the year 2023. By interim orders, I was already asked to pay maintenance. So till 2023, I continued to pay. Now, when in 2023, it said that 2020 is my limit.
data.
I have already paid excess amount. So now the question of me depositing any awarded amount doesn't really arise.
Yes, it seems so.
Take instruction. That's why, my lord, I initially submitted, my lord.
This present petitioner before us is
It's
the wife,
The
Is
son is not
against
even-
whom there was no award.
There was no award.
Against whom, my lord, the learned trial judge has said she is not entitled.
She's not entitled.
She is not entitled to get maintenance.
As
Under-
of now, as till today, there is no, award again for her.
No.
For wife, yes.
For wife.
Correct. Now,
Hmm.
I am for the wife, my lord. My bone of contention is that the learned trial judge has failed to appreciate the evidence and materials on record.
So as per you,
And-
she also entitled.
And
That-
she
that
is
of
also.
course-
she
That,
also
that
entitled.
aspect is okay, but
That,
now,
that aspect of the matter, your lordship will examine, my lord, during the course of my lord hearing. Now, so far as my learned friend has submitted, my lord, that is why, my lord, at the very inception, I have submitted, I have to respond, my lord, to the affidavit filed by him. What he has submitted, my lord, that is the affidavit that is filed today. Now, I have to take instruction, I have to respond on that, my lord. That is why
okay, then we'll make a just simple observation in
My-
regards to order passed on 21st of, because as per the award,
My
there
lord,
was no such award for the present petitioner
my lord.
regarding the payment of 10% so and so.
My lord.
That observation, simple observation will make. And you will fix it the date. If you respond, you can file one petition. Because your entire case is not only the 10%, 20% award, but it was that your case is that against you, I mean, for you, your favor, there was no award of order.
Correct,
Okay,
correct.
hard. You are Mr. D?
BK Sen.
Oh, sorry, BK Sen. Hard Mr. BK Sen, the learned counsel for the petition. And also hard Mr. B.T. Deka, the learned counsel appearing for the respondent number 1. And Mr. B. Waterford, the learned additional PP appearing for the state respondent number 2. The affidavit in opposition has already been filed. In that context, Mr. Sen, the learned counsel for the petitioner, submitted that he will take some instructions to respond or reply to the affidavit in opposition. Next para. Mr. Deka, the learned counsel for the petitioners, also submitted in this regard that as per order dated 21/2/2025, it was directed for payment of 10% of the maintenance amount to by the respondent, but as per the award, as per the order, judgment and order passed by the learned principal judge, there was no the maintenance for the present petitioner was denied, and hence there is no such order to pay for payment of the maintenance against the present petitioner. However, the order of maintenance for the son was there, and they have already paid the excess amount to the son of the petitioner who had already attained the majority.
That
Next.
part I need to take.
No, no,
instruction,
no, no.
Attainment
That-
of majority,
Yes,
yes.
yes. In that context, Mr. Deckard submitted that he will take proper instruction from his from the petitioner and will file if a different reply to that. Let then you want any next week will do, or you want any fixed date here?
2 weeks, my lord, because.
2 weeks.
Yes, my lord, because he resides Karimganj, my lord. He'll have to come and.
Then we are listing it after 2 weeks.
Right.
Okay. So I just made a clarification in the regulatory submission
My lord.
that 10% is not there in fact.
Because I had to pay by today.
That's why
perhaps,
that
my lord, by mistake, my lord, my instruction was that, my lord, the maintenance to the son was not awarded, my lord. It was not paid by the father. That is what, my lord,
But there are some confusing or contradictory statement is there, because in the award itself, if you go by the award, there it is that he will attend the majority till 2020, or something
Correct,
so on, said
correct,
2020, but
correct.
order was passed on 23. So up to 23, most probably the maintenance was there, but by him.
I kept paying, my lord.
He
Because
kept paying. So I don't know if that may be the position. I don't know. So 10% may not be possible at this stage.
My lord.
So that's why I made a clarification, because 10% was order was there on 21/2. You submit on the next day, take instructions and submit reply also. Okay. After 2 weeks, good. Okay.
Deeply obliged.
Into 14 assembly. There are lots, no? How many matters are there? Two? At two? One matter was there. Who was looking after that matter? You took time. Then one of our colleague was, Mr. Sharma was looking after 24, 25. No. 24, 25. Oh, sorry, 25, 26. Already been fixed? At 2 p.m. Yes. Okay. Oh.
Under section 195A of IPC, which is pending before the learned traditional CGM Kamrup panel. My lord, kindly for a moment, page number 17, the complaint. Relevant portion is at page number, my lord, 18. May I read, my lord?
Yes.
That the complainant is a citizen of India and the permanent resident of village Bolaga, Priya Spolasbari, Kamrup, Assam, who is well within the jurisdiction of this honorable court. Number two, that the complainant begs to state that on 11/8/2021 at around 10:30 PM, one Iman Ali and Anwar Ali took the brother of the complainant, namely Asif Ali, from the house of the complainant to the house of accused Shiraz Ali, stating that Iman Ali has called the brother of the complainant in order to settle some accounts of loan and thereafter ration shop, and they also stated to the complainant that they would drop the brother of the complainant at his residence. Thereafter, the said Imam Ali connected the call with Chandana Begum and gave the mobile phone to the brother of the complainant, when the brother of the complainant stated that he do not want to go at this late hours of night. Then Chandana Begum asked the brother of the complainant to accompany the Imam Ali and Anwar Ali. Accordingly, the brother of the complainant went to the house of Shiraz Ali, wherein the Chandana Begum was also residing. On that particular night, the brother of the complainant did not return to the house. On the next morning, Chandana Begum had called the complainant over phone and informed the complainant that the accused number one, i.e. Shiraz Ali, has called the complainant to his house, and when the complainant went to the house of the accused Shiraz Ali, the accused informed the complainant that the brother of the complainant had committed suicide. The complainant had a reasonable suspicion that the accused person, with the help of his aides, has committed the murder of his brother. Accordingly, on 12/8/2021, the complainant, being informant, had lodged an FIR before the officer in charge of Polasbari Police Station to the effect that, and the said FIR was registered as Polasbari PS case number 542/2021, dated 12/8/2021, under section 302(34) IPC. That the complainant begs to state that after registration of the instant case, the investigation officer investigated the case, and after completion of the investigation, the concerned investigation officer laid charge sheet in the case, height charge sheet number 261/2021, dated 30/9/2021, under section 306(34) of IPC, against the accused person, namely Imam Ali and Anwar Ali and Chandana Begum. And the case was registered as session case number 103/22. That the complainant begs to state that the case was made over to the Court of Additional Sessions as Kamrup at Tamingau for disposal, and Honorable Court was pleased to frame charge against Imam Ali and Anwar Hussain and Chandana Begum for offence punishable under section 302(34) of IPC. Number 5, that the complainant begs to state that the complainant that accused Shiraz Ali and the persons who are accused in session case number 103/2022 are resident of same village, i.e. Bholagao, and the accused Shiraz Ali is an influential person having both muscle and monetary power, and after framing of a charge in session case number 103/22 has been trying to influence and threatening the complainant and his family members to give false evidence before the Honorable Court of Additional Sessions as Kamrup at Tamingau in session case number such and such. That the complainant begs to state that the complainant, after receipt of the summons from the Honorable Court of Additional Sessions, have adduced his evidence on 18/8/2022. This para is relevant, my lord, wherein he had narrated the actual fact leading the date of the victim and stated the name of the accused Shiraz Ali and Tarzan Ali, and also narrated the role played by Shiraz Ali on the date of incident and subsequent thereto in his evidence in chief. And since then, the accused persons became more violent toward the complainant and his family members, and directly started threatening the complainant to adduce false evidence during his cross-examination in order to save the accused persons who are presently facing trial in session case number 103/22, and also the accused number 1 and the Tarzan Ali. Number 7, that the complainant begs to state that the accused person has also used various means to put pressure upon the complainant and his family members to adduce false evidence before the Honorable Court. And one of such means is that the accused number 1, using his monetary power and muscle power, has renounced the complainant's family from the society without any basis, and the said fact is also known by the village headman, and the village headman has issued a certificate to that effect. Number 8, the complainant begs to state that the above named accused persons from very beginning of the initiation of the trial of session case number 103/22 has been continuously threatening the complainant and his family members to get false evidence so as to save the accused person, namely Chandana Begum, Anwar Ali, Imam Ali, and also to save the accused number 1 from the ensuing legal consequences. The complainant begs to state that the accused number 1, along with the other accused Imam Ali, from the very beginning of the initiation of the trial case number 103/22 and soon after adducing evidence in chief by the complainant before the Honorable Court, has been continuously threatening the complainant and his family members and also the material witnesses of the case to adduce false evidence before the Honorable Court in order to safeguard the accused persons who are facing trial, and the complainant, finding no other alternative in order to save himself and his family members, have filed one intimation narrating the above said fact before the Superintendent of Police, Kamrup Amingau, and BJP headquarters such and such. That the complainant begs to state that the accused person have also threatened one of the listed witnesses of session case number such and such, namely Mazhar Ali, son of Mofiz Ali, and the said witnesses were repeatedly called by the accused persons to their residence, and they have asked him to adduce false evidence in the case, and the said witnesses could not bear the potential threat of the accused persons, and finding no other alternative, he had left the village in the month of December 2020. My lord, in this case, the learned court will rightly take to cognizance. There is no, my lord, infirmity, my lord. Kindly for a moment, my lord, section 210 of BNSS, my lord. Earlier 190, taking of cognizance by the magistrate. Magistrate can take cognizance either in complaint or in a report submitted by the police. Now, my lord, for a moment, 216 of BNSS, my lord. Procedure for witnesses in case of threatening, etc. A witness or other person may file a complaint in relation to an offense under section 232 of the Bharatiya Nyaya Sanhita. That means, my lord, 195A, earlier 195A, now 232, my lord. My lord, my lord, kindly, I am reading, my lord, section 195A. Here in this case, cognizance taken by magistrate, my lord, under section 195A of IPC, my lord. May I read, my lord? Whoever threatens another with any injury to his person, reputation, or property, or to the person or reputation of any in whom that person is interested with intent to cause that person to give false evidence shall be punished with imprisonment of either description for a term which may extend to 7 years, or with fine, or with both. And if innocent person is convicted and sentenced in consequence of such false evidence with death or imprisonment for more than 7 years, the person who threats shall be punished with the same punishment and sentence in the same manner and the same and to the same extent such innocent person is punished and sentenced. Now, my lord, classification. Classification of offense. Para 1, cognizable, non-bailable, triable by the court by who is offense of giving false evidence is triable. Punishment 7 years or fine or both, non-compoundable. Para 2, my lord, cognizable, non-bailable, trial by court by who is offense is giving false evidence is triable. Now, my lord, kindly see section 232 of BNSS, my lord. Commitment of case to court of session when offense is triable exclusively by as because the complainant alleged that we are giving threaten in case number 103 of 22, which is pending before the additional district and session judge. So far as the classification of offense, my lord, this should be triable by the court of additional session judge, my lord. Learned magistrate, my lord, to cognizance under section 195, there is no any infirmity, my lord. But, my lord, we have the accused person appeared, my lord, seeking bail. They have been enlarged on bail, my lord. And now the case is fixed for evidence before SARS, my lord. So, my lord, this part, the magistrate could not done this, my lord. As because soon after appearing the accused person, the case should be committed before this, my lord, session. So far, section 232 of the BNSS, my lord. Yeah. Now the case is fixed for evidence before SARS on 9/4/2020. So, my lord, the learned could not put the evidence, my lord, as because that case is pending before the additional session, as my lord. So far, section 195 as per classification.
Classification?
The classification of offenses, my lord, 195 classified that this case should be tried before the court where the witnesses are threatening for giving false evidence.
In that case, false evidence has to be adduced.
My lord.
Here, it is not been adduced now, till now. It is the allegation that you have threatened. You have threatened.
Yes, we are threatening to adduce false evidence in connection with the case 103/22, which is pending before the additional district and session.
Yes, yes.
My lord. So, my lord, they did not make any objection before the concerned court, my lord. They did not make any objection before the additional district and session. They have filed a complaint before the magistrate. Magistrate tried to take cognizance, my lord. They have, my lord, kindly for a moment, my lord, order dated, my lord, 6/11/24.
Taken under which section?
195A.
A.
195. So, my lord, at least this notice may be issued, my lord. And the subsequent proceeding may be issued, my lord, at least this stage, my lord. Additional CGM. Page number 25. Order dated my lord 6/11/20. Additional CGM. Right, so what is the demonstration that we will be moving from 127 plus additional side, actually, side of the. I think it's 195. I think it's 195.
Therefore, we are saying that it has to be committed. I don't know, I'm just not
My
finding.
lord, should, my lord.
Is there any Mr. Das? Question is that 103, session 103 is pending.
My lord.
With the allegation of 306 and subsequently 302, the charge was framed. Here it is alleged that the accused persons are continuously threatening the complainant and his family members not to adduce evidence or to give false evidence. So this is another cause of action error, that there is a threatening the persons not to go or not to. But it's not a case that false evidence was already adduced before the court on the threatening. That is not there. So I don't know, I am not finding difficult to understand then why it should be committed. Why it should be committed, that is part 1, part 2 I have gone through. The question is that if the false evidence is already adduced, suppose.
Not adduced,
in
yet
that
not
case, but it is a cause of action newly arise that they are threatening us to give false evidence.
My lord, kindly
So,
for a moment.
whether, okay, then we are issuing notice at this
Issue-
stage. I'm not
notice,
finding any.
This notice may be issued, my lord.
Okay, notice may be issued. Anything, any.
No power of taking cognizance by the. Rightly taking cognizance. There is no bar for taking cognizance.
So you are only on the fact that the death has to be tried by the session.
Session.
That is there
At the
anything?
same-
Is there anything Mr. Das in that paper?
Lordship, it is stated here in the comment or part, Lordship, in the 195A, that the tried by court by which offense of giving false evidence is triable, but here evidence is not given, Lordship.
That's what I'm saying.
Evidence is not given.
Evidence is not yet adduced.
Not
It is
yet.
a
My lord,
threatening.
examination chief has been
Or
recorded, my lord.
Otherwise also from his submission
Okay.
or from the complaint
Lord-
itself that the person, that the complaint was also threatened, but he had already adduced evidence. That was
My lord,
false evidence.
Examination chief has already been recorded.
And thereafter, he had not adduced the false evidence. He properly adduced the false evidence. Thereafter, the threatening was more,
My lord.
that you may be with some dire consequences. But the question is, and that's what I'm just,
Notice may be issued there.
okay, issue notice at this
My
case.
lord.
Hard করে দিব, this case of so and so করে দিব, issue notice করে দিব. How many respondents are there?
2 respondents.
2 respondents.
State of Assam and my lord.
State of Assam, no need to, for state of
That's-
Assam, occur na lage. Only issue notice to the respondent number.
1. Jabbar.
He is 1, state is 2.
State is 2.
State is 2. 1. eh? And otherwise, what is the case of now the evidence before charge?
Evidence before-
Charge is not yet framed.
Not yet.
So you are here for against the order of cognizance, or you're saying that cognizance is rightly
Implied
taken?
complaint, my lord, and the subsequent proceeding.
No, you are again here for against the order of cognizance or
No,
order
my
of
lord.
committee, what?
Entire complaint for quashing the entire
Then
complaint.
why are you submitting that it should be committed and all? That may not be, maybe a case of quashing, I don't know,
My
at
lord.
this stage.
My lord,
Maybe a
notice
case of
may be
quashing,
issued at this-
notice issue করে দিব ওখানে।
at this is-
It can be fixed at after 3 weeks,
My lord,
least after 3 weeks.
highly honest.
This was item number 8, no? Yes.
25 and 26.
May please, your lordship. It's a regular bail application, my lord. Petitioner was arrested, my lord, on 1/1/2025. Under the charge, my lord, UAP and my lord, some section of my lord DNS, my lord. As on date, my lord.
Mr. Boroi, you want to disconnect it?
My lord, that will be there, my lord. I only place the, my lord, what are the, my lord, materials found, my lord. Only, my lord, that I has made a note, my lord. Because there are several accused persons, my lord. So each and every, against each and every accused person, my lord, I have made a specific note, my lord. What are the, my lord, materials found against them, my lord? And why, my lord, their father is in my custody interrogation.
No, if you want to submit this one, otherwise, we'll switch off this one or I don't
It will be
know.
open, my lord. I'll place the, my lord, relevant, only the relevant for some.
So live will be there?
Maybe.
As on date, my lord, 76 days in custody, my lord. Here, my lord,
You are for how many petitions?
one petitioner.
One.
Only one accused in both the cases.
So he got arrested on 1/1 and 76 days.
76 days, my lord. In 25, my lord, I was originally arrested on, my lord, on that day, my lord, and thereafter in item 26, my lord, I was shown arrested in another case. My lord. And lordship may kindly see
In
that
earlier one, you were arrested in connection with?
1/1/2025, my lord, that is the date of original arrest, my lord. And subsequently, my lord, in 26, my lord, I was shown arrested.
Shown arrest.
Shown arrested. My lord, kindly have a look at
Shown arrest, date of shown arrest.
date of shown arrest, my lord, 21/2025, my lord, 56 days. 20, item number 26.
So item number 26, it is
56 days, my lord. And 25
when you got shown arrest on 20,
on 21/2025, my lord.
21/2.
21/1. 2001, my lord. 2001.
2001.
1/25.
20th January,
Yes, my lord.
you got shown arrest.
Shown arrested.
Same allegation or?
Another FIR, my lord. But in both the FIR, my lord, my name is not there, my lord. So, my lord, general FIR, my lord, kindly have a look at page 11 of item number 25, my lord, where I was initially arrested, my lord.
Page 11.
Page 11, my lord. Merit.
Hmm.
Merit.
Hmm.
This is to inform you that various information has been received from the special branch of Assam Police and other source of another source that United Liberation Front of Assam, independent in source Alpha I has carried out large-scale recruitment of cadres with the intention to prepare various subversive and terrorist activities through their cadre as well as their OGW linkmen. One Alpha I leader SS Major Aising Assam has instigated the youth of Assam into joining the band outfit, employing various methods of fraud and deception through social media, WhatsApp, Instagram, Facebook, etc., and has also generated anti-national, anti-Indian feelings among the youth of Assam and lured them to join the band Alpha outfit. It is to be mentioned here that Alpha I has been collecting weapon and explosive substance and waging war against the government of India. Alpha I has thus not only disturbed the law and order situation and economic growth of the state, but also has created various subversive and terrorist activities to pose threat to the sovereignty and territorial integrity of the state. Further, various inputs have been received from the special branch of Assam Police, Central Intelligence Agency, and other credible sources that Alpha I leader have served multiple extortion demand to some businessmen of Saradhu district through mobile phone or through their overground worker OGW and linkmen. They have threatened the businessmen and with dire consequences if they disclose or reported the extortion demand to law enforcing agencies or police. Moreover, credible inputs have been received from Alpha I has engaged some person from Arunachal Pradesh and Nagaland as middlemen to collect their
extortion money from the businessmen of Assam who have been doing business in the interstate border of Assam, Nagaland, and Arunachal Pradesh. There are imputes that Alpha Trader have been trying to enter Assam through the porous interstate border area of Sraidur district with a plan to kidnap a resourceful person for ransom and to compel the state to give in to their demand. Further, various imputes have been received from Alpha leader that have been planning to carry out subversive activities with the use of firearms and explosive substance with the intent to stake terror in the people and also cause the death of public functionaries. Imputes have been received that Alpha leader, namely Lieutenant General Nayan Assam alias Nayan Mehdi, SS Brigadier Ganesh Lohan, SS Colonel Akon Gogoi alias Pratip Assam alias Petu have allegedly committed extortion and placed extortion demand to various businessmen of Sraidur district. Credible imputes have been received that Alpha has engaged many persons, including habitual offender, vehicle lifter, OGW, and linkmen to carry out the extortion on their behalf. Alpha has also allegedly engaged criminals who are out on bail to carry out extortion, sabotage, and various subversive activities. One person named Wang Pen, who is the Renapio of Upper Tiru of Nagaland, has allegedly provided logistic support and safe shelter to the Alpha Trader with the help of two other persons, namely Obed of Upper Tiru of Mon District, Nagaland, number 2, Hoilong Kanyak of Naginimara Mon District, Nagaland. Moreover, there are credible imputes that many businessmen who have received extortion demand have their either unlawfully paid or have planned to pay the extortion money to Alpha without informing the police. This act tantamount to terror funding and voluntarily concealment of the act of finding a banned militant organization, because Alpha allegedly used the extortion money to recruit, cater, organize terror camp, and procure firearms, bomb, IED, and other explosive substance, and to import training to carry out sabotage and other substantive activities against the government of India and the state government. Moreover, Alpha also uses the extortion money to engage various criminal elements to destabilize the economy and economic security of India. So then I'll affair my lord, nowhere my lord, my name isn't appearing. And in connection with this case, my lord, many person has been arrested, my lord, somewhere already released on bail, my lord. And my lord, only on suspicion, my lord, I was arrested, my lord, and as of date, my lord, 73 days in custody, my lord.
So you're saying that your name is not there?
Not there, my lord, and my lord, only on suspicion, and moreover, my lord, already 76 days, my lord, period of detention, my lord. Whether, my lord, my further custody introduction is required, my lord, in connection with this case, my lord.
My lord, this accused person, my lord, although he has not been in the FIR, my lord. For the other accused person also, my lord, there are as many as 13 accused persons, my lord. So, my lord, all the accused person, my lord, none of the accused person probably, my lord, named in the FIR, my lord. But, my lord, during investigation, my lord, this accused person name has been revealed, my lord, and during CDR analysis, my lord, this accused person was arrested, my lord. But now, my lord, exactly, my lord, what this accused person has, my lord, done, my lord, and what the investigation has found, my lord, this is a short note, my lord. No kindly query. Petition is still pending, my lord. So, my lord, at this stage, my lord, I am opposing it bill.
And my lord,
Otherwise, on the prayer, it is 180 days of it, I think.
My lord,
Otherwise, on the prayer of the, I was supposed further investigation, it is how many days? Custody, 180 days.
it can be extended, my lord.
if my lord prayer made, my lord, otherwise my lord already 76 days.
Obviously. Okay, now this is in connection with 25.
25.
So what is 26?
26, my lord, FIR is at page 23, my lord. In that case also, my lord.
In this case, my lord, he has been shown error, my lord.
So no,
Item 26.
Page 23, my lord.
Because, my lord, he was already arrested in connection of Sonari PS case, my lord. So when, my lord, some, my lord, materials has been collected, my lord, during investigation, my lord, that is why he has been shown errors, my lord. He was produced before the concerned magistrate, my lord, and he was interrogated, my lord.
Page 23, my lord, it's not FIR, my lord. I read the FIR, my lord.
Hmm.
With due respect, I would like to inform you that on 25/11/2024 at around 6 AM, my husband Muhammad Musalik Ali, resident of Sasansas, district Shaidu Assam, while he was at his shop, some unknown Naga armed personnel riding in a Tata Sumo vehicle forcefully entered into the premises of his shop, abduct him and took him towards Nagaland. While they were abducting my husband amidst that altercation, a small bag, black color, fell down from the possession of those individuals. Later on, it came to my knowledge that a bomb was recovered from the said bag. This case, my lord, perhaps, my lord, there is no, my lord, involvement of the petition
This case.
in this case, my lord. This, my lord, to be.
Yes,
Right.
what about this one?
This case, my lord, although, my lord, investigation is still pending, my lord. Although, my lord, he has been not been connected to the directly, my lord, with the, my lord, kidnapping, my lord. But he is, my lord, he is the person, my lord, who was in constant touch with the all 4 kidnappers, my lord. Because person has been kidnapped, my lord, and 20 lakh rupees was, my lord, demanded, my lord. And from the case diary, my lord, it is not clear, my lord, whether that person has been, my lord, recovered or not, my lord. Secondly, my lord, he has shared, my lord, the video footage, my lord, when, my lord, the person was kidnapped, my lord, a video was done. So he has shared a video, my lord, to other, my lord, to other president of the, my lord, NSCN leader, my lord. He has shared a
Video was?
video of the, my lord, kidnapping, my lord, kidnapping video. It was recorded, my lord. While the kidnapping was done, my lord, the video was recorded, my lord. He has forwarded that video, my lord, to the, my lord, NSCN leader, my lord, and he was in constant touch with the, my lord, four kidnappers, my lord. That has come during investigation. And from the date of shown arrest, my lord, today is 58 days, my lord. And investigation is still pending, my lord, because that person has not been recovered, my lord, as affected from the case diary, my lord.
It's not yet recovered.
Not yet recovered, my lord, from the investigation details. As on today, my lord.
Yes, okay. Yes.
Mainly, my lord, period of detention, my lord, whether my further custody integration is required, my lord.
Okay, whether CD will be required, my lord.
May gone through. You flag the flag, you have flagged.
Yes, I have flagged it, my lord. My lord, in this case, my lord, I have put a, my lord, pink flag color, my lord. The lordship may kindly fill. Others, my lord, no, is not required.
খালি অলপমান পাৰ্টটো আগবঢ়াই থব অলপমান আগবঢ়াই থব লেটাৰ পাৰ্ট মই ফিৰোজৰ প্ৰিচিডিং দি দিম ফাৰ্ষ্ট পাৰ্টটো হাৰ্ড মিষ্টাৰ আইটেম নম্বৰ 25 heard Mr. K. Borba, the learned counsel for the petitioner, and also heard Mr. R.J. Borba, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. So the receipt, there is the same hard both side. It is submitted by Mr. Borba, the learned counsel for the petitioner, that the present accused petitioner was arrested in connection with this case on 1/1/2025. Until date, he is in custody since he is in custody for 76 days, and thus the IO was sufficient time for his custodial interrogation. Further, he submitted that in the FIR, the name of the present petitioner is not mentioned, and he is no way related in the alleged offense. However, during the custody, he cooperated the IO in the investigation of this case, and investigation of this case post. Further, he is ready and willing to cooperate the IO if he is granted with the privilege of bail. Post. Next paragraph. Mr. Borba, the learned additional PP, submitted in this regard that from the materials available in CD and from the note of the IO, it is seen that the present petitioner is fully involved in the alleged offense of he is also I mean, link man, no?
Linkman,
No.
He's
Not only
directly
linkman.
linked with
Link-
NSCN and Alpha, my lord.
Yes.
And there are some other accused person, my lord, they are yet to be appeared.
Submitted that the present from the materials available in this so and so, it is seen that the present accused petitioner is a link man not only for the NSCN, but he is also taking part as a link man of the Alpha I cadre.
He collected money, my lord.
And that apart, he also extorted money for the said organization, and directly he is he is involved directly in the said in the case. Further, it is submitted that that there are several call details which were recovered during the investigation, wherefrom it is also seen that there were a long discussion in regards to unlawful plans to disturb the peace and harmony in the Assam. And thus he is, and accordingly he submitted that full stop. Mr. Burua further submitted that the case based record is still under process of investigation, and his custodial interrogation may be required to unearth some more facts in this case and to nab some other culprits which are yet to be and to nab the other culprits which are connected with the alleged offense. Accordingly, Mr. Burua raised objection in granting bail to the present accused petitioner. Bakiখিনি talk মই এইটো ভেকেন চাই ল'ম হা নেক্সটত আহক আপুনি in item number 26 দেখক আর Mr. So-and-so, same থাকিব. It is submitted by Mr. Borwa that the present accused petitioner is no way involved in the alleged offense, nor there is any allegation brought against him in the FIR. However, while he was in custody in connection with the other case, in connection with Sonari PS case number 124/2024, the present accused petitioner was shown arrest in connection with this case on 20/01/2025, and since then he is also in custody in connection with this case. Mr. Borwa further submitted that from the plain reading of the FIR itself, it is seen that the present petitioner is no way involved in the abduction of the husband of the informant who lost the FIR, and accordingly, considering his length of detention, he may be released on bail. However, he is ready and willing to cooperate the IO in further investigation of this case. Next para. Mr. Borwa, the learned additional PP submitted in this regard that though the name of the present petitioner is not available in the FIR, but from the materials available in the case record, a case diary, it is seen that he was continuously in touch with the kidnappers who abducted the husband of the informant, and the IO has already collected the call details, etc. during investigation. Thus, there may be some of the co-accused persons are yet to be nabbed in connection with this case, and accordingly, Mr. Borwa raised a payment objection in
Team is
granting.
not yet recovered, madam. The person who has been.
Awesome. And then payment objection in granting bail to the present petitioner. Further, he submitted that the person who was abducted is yet to be recovered, and the investigation is still under process. I'll pay the case diary and pass the order. Other case diary. What do you dispose of?
Finding 52.
Morning was mentioned for filing of IA. IA for correction of that particular thing. I've inquired from the wife. Is it is time is defective or something. In IA also. In IA. No, she inquired the matter, so in IA also, IA is also defective.
Rectify that, my lord, on 13.
No, for rectification, you file the IA, but IA itself is defective. That's why it is not become taxable direct. For some typographical correction, you have filed the IA for correction, but the IA itself is defective. You just inquire the matter with the registry, it's still lying in the registry.
Still, we rectify the I also, that's on 13.
That is not with us. You have filed the IA.
Yes.
No, today you have filed what IA?
No, we file on 11, my lord.
She inquired the matter that the IA which have been filed by you for correction.
Yes.
Typographical said that is itself is defective. So that is still lying in the office of the registry. You just go and inquire the matter in the registry whether it's still lying. And if it is defect is already corrected by someone as a submitted, then it may be before us, but today it's not before us because it is always still defective. That's why it could not be sent. Okay. So to do you simply will list it. You just inquire about the matter. Will not pass any order, will simply list it.
Date may be fixed, otherwise we have to make mention, my lord.
Yeah, you have to make mention because it's not before us. It's a AB.
AB.
It's a AB now. List after 1 week. List after 1 week, within 1 week, you make a mention and correct. List after 1 week.
For admission 15 and 16.
AB.
That my lord, vehicle is with me at Rajasthan. Your lordship is remembering my lord. Your lordship passed order AB my lord, very elaborate order. AB number 3375. Your lordship order is 2012.
Yes.
Yes, very elaborate order your lordship has passed my lord.
Ah.
Vehicle is with me, that at Rajasthan. Only number is same, chassis number, engine number different. So my claim is that I was not there, my vehicle has never come to Northeast region, my lord. It is with me till today, and your lordship observed my lord also. Now your lordship made in my lord observation direction, court below, to make an inquiry as to whether the vehicle seized in connection with this case is similar or the same vehicle for which the petitioner is claiming ownership. Your lordship, what are my lord last part, your lordship. So now my lord, my advocate below, he has filed an application before the court with some documents on behalf of the client, my lord, to comply your lordship order, my lord. He is not accepting that application, my lord, saying that now he is to come here. So my question, my lord, we will submit all the papers, my lord, whatever is required, my lord, to my advocate, because we are coming from Rajasthan and your lordship protected him before till his appearance. The next date is fixed on 20, there, 205, for appearance.
Your lordship may kindly peruse the order passed by your lordship on my lord. 2012,
2012, that is what I am saying.
My lord, last paragraph, my lord.
That is what I read just now.
But your lordship has made specific direction for appearance of the my lord accused person, my lord, but till now he has not appeared.
No, the appearance means, my lord, your lordship, till appearance. Your lordship is not directed to appear, my lord. Your lordship kindly see your lordship order. I find it justified to stay, suspend the NBW as well as issued against the present president till his appearance before the learned court below.
Yes, that's so.
So appearance, my lord, next 2205, I file an application that is allowed till 25. Next,
May, up to May.
Up to May, next date is fixed, madam, for appearance. In the meantime, why my prayer is, my lord, your lordship order is that direction, I am ready to, my lord. Only it is maybe submitted to my advocate, that your lordship can be observed that we will submit it everything to the court, my lord. They will make an inquiry.
No, the question is that your NBW PNA is also stayed.
Right.
With a direction to the learned trial court below that till his appearance, it will be stayed or suspended.
Right.
And he will make an inquiry regarding this,
Right.
as you have submitted that chassis number, because before us it is not here.
Yes,
So
it is
he will make an inquiry.
Yes.
So till his appearance before the learned trial court below, your PWN. But without appearing, if you go through an advocate, you engage through an advocate, then your conduct will definitely come.
That is what
How
I am
can
saying,
you
madam.
engage? Yes.
That is what I am saying, madam. To advocate, I may be allowed to file my documents before the court.
No, that won't be, I think.
So once it comes, my lord, then again it may be.
No, by that time, what is the inquiry? By
It
done
will
by
not
the-
make my application, my advocate filed an application in reference to this, your lordship's order, my lord. Court did not accept the application, my lord. That is why I reported, madam. Copy, I will get it, my lord, today or tomorrow, my lord, I am getting it. Copy which is submitted, the application which is submitted. That was not been entertained, my lord. That is reported from the advocate side.
Yes, otherwise, well, I have gone through the LCR, my lord. Whether from the LCR, my lord, there I have not found any record regarding the placing of the present order passed by your lord.
Not entertained, not accepted.
On 2012-2024, and from that order, my lord, it specifically reflects that your lordship has, my lord, suspended the PNA and NBW till his.
You have not placed this order also.
Yes, my lord. With this order, I have submitted an application before that. My advocate submitted. That is what I am saying, my lord.
But that is not there in your,
That
LCR.
application was accepted, my lord. That is what I am saying, my lord. I filed the application before the court. I have given it along with that.
Accepted, not accepted will come later, but on the application, if you file,
Yes.
that may not be accepted, that the order will
I
be
can
there,
show
order
you,
is there.
lordship. I can show because, but it is coming by today or tomorrow, my lord. I asked him to send it so that I can place your lordship, my lord.
No,
Number
while
6.
rejecting your prayer, suppose prayer may be rejected.
Not
Because it may-
rejected also, my lord.
Huh?
Not rejected also, my lord. Rather, he was allowed to, for example, till next year, his appearances, file application because in terms of your lordship, what are file an application. So that was allowed also, my lord. But so far inquiry part is concerned, the court is not accepting it until and unless he comes. Appearance given, my date is given, extension is given. So there, during this period, I may be allowed to, that is what I'm saying, my lord. Only my time to submit my papers for the inquiry will be made from Rajasthan, my lord. So they'll have, it must go from the court. So I am simply, I think it is reasonable subject to your lordship, my lord. Only I want to place all the papers to my advocate before the court, and next day I'll appear, my date fix, I certainly, my lord.
Then again, it will be against my own order. then.
And my lord, your lordship, here in the petition, the one search sheet has been annexed, my lord. And your lordship, I have also got the copy of the search sheet from the learned trial court, my lord. Your lordship, one, my lord, paragraph of the search sheet filed by, along with the petition is missing, my lord. Your lordship may kindly peruse. Well, I have back side, yes. Yes, not
That we did not get it.
I have flag mark, my lord, back side of the last page of the.
Now it is available in the city, my lord, that's very soon, my lord. Here we have been given certificate as it is, my lord.
That, my lord,
Yes.
LCR is annexed along with AB number, last page. Back.
One page missing.
One
Yes.
page on the back side of the.
This
last
thing, my lord,
page.
backs one page, my lord, your lordship will find.
Regarding the
I will show
owner of the
you.
present
Sir.
vehicle, my lord.
On a page.
The IO regarding the why, my lord, supplementary search sheet have been filed against Raspal Singh Punia, my lord, the present petitioner. My lord.
Huh?
Well, I will point out.
Yes, I have seen.
But that is not there in the, my lord, petition.
Your lordship will find page 61, 62, my lord. 62, 63.
Of AB or other.
This is,
Similar petition.
this
But
is AB, AB.
LCR is annexed along with the AB. my lord.
Oh, no, criminal petition is what kind, this criminal petition.
Criminal petition, there is no LCR, my lord. Because,
No, yes, same, I have
Yes,
filed,
yes,
my lord.
same.
Same thing. There one page is not there, page 62, your lordship. Okay, certificate will be set up. Come on. That is, yeah.
Oh, you have not annexed one page. Yes.
So your lordship kindly see, my lord, page 62, 63.
Yes.
62, your lordship, we have been given as it is, my lord. So if it is in the record, my lord, that will be there, I think there is nothing, I think no, it will not
But
contact.
one paragraph is missing here.
One paragraph, number page 17 is there, 17. Your lordship can say page 62,
No,
serial number 17.
Para 17 is continuing till next page.
Exactly, exactly.
That will be
Then
missing.
paragraph 24 comes. In between, it is not there. In between, my lord, page 63, it is 24, list of the enclosures.
Have you annexed the order of the where your petition is not accepted, or was there any order?
That one, the new one.
Hmm?
No, this is what I'm saying, the petition is coming, madam. In the meantime, madam,
But the question is that he was asked to appear, and for till appearance, his home in the meantime make an inquiry. But the court below did not inquire anything from Rajasthan and all.
Regarding
Because
that,
inquiry can be done by the court itself.
whether my learned trial court as my learned senior has submitted that order has not been accepted. I don't know
what
about
are
that
application?
application. Along with the application, that order, whether my learned trial court has gone through that portion of the paragraph, that also needs to be pointed out. My
Because as he submitted that
Yes, ma'am.
here, the petition order for order passed in AB is not available. That means till now that was produced or not produced, we are not know.
It is not available.
We do not know.
But
Yes.
we have submitted along with the copy, well, that is proof is there along with the seal, etc. madam. But I could not produce it because it is not available with me right now. Tomorrow I will be getting it, madam. That part. But
When
in
your
the
lordship-
meantime, what I mean to say, my lord, as your lordship rightly pointed out, court can make its inquiry on its own, my lord. And your lordship order is very clear, my lord. The trial court below, however, the trial court below is hereby directed to make an inquiry. That can be complied, my lord.
Then, my lord, your lordship may
Yeah.
call for a report for registry, my lord, in persons to the order earlier passed by your lordship
a report on the basis of the last
Whether
paragraph.
an
and-
But
inquiry is made of.
if the court is not supposed aware of that order,
Yes,
so
that is the
that is
that
one
is the
thing.
difficulty, my lord.
That is the
whether-
difficulty.
But
So we are not in a position to say whether this
So,
order is available with the court or not.
my your lordship kindly let fix it day after tomorrow. I will get it.
Day after
everything.
tomorrow, lots of matters have been fixed, I think. Day after
I
we have
lift your
fixed.
lordship, my lord. Everything is there, my lord. I will get it. Only problem is because the advocate has got some
Friday, could
problem.
you find Friday? Friday, let it
Right.
be on Friday.
In the meantime, get everything clear on.
Yes, and by that time, if court is not aware of the order dated 2012, that may be one of difficulty on the part of the court also. How would they?
Certainly, no. That's I understand.
But otherwise, the one question is also there. His appearance, time of appearance is extending by the court.
Yes.
So if it is not aware about the order, how
Yes.
the court extending the time period? Because stay of PNA and NBW was
Yes.
there.
Time that order. So I will have, my lord, only
no, I
after submission of all the documents.
It was submitted, especially he informed me, my advocate. He has shown it, my lord, before the line of court also. My.
Otherwise, my lord,
Application was not accepted.
otherwise, my lord, the direction of your lordship is also there, my lord, for appearance of the.
Yes, still appearance only.
Because on that day, if, my lord, he has not appeared because of that, that may also be one of the.
Yes, yes, one of the count. That's what I'm saying. Okay, then we fixing it on 21st. Supply us order and also make an inquiry whether on the what basis the court is extending the time of his appearance. Because if it is not, nothing is able, otherwise PNA is also issued against him.
Yes.
Not only NBW. So in that case,
No, it
if
was
there is no
submitted-
stay order is not there.
Your lordship,
So it is this one question to be
was submitted, my
determined,
lord.
but otherwise without anything, how?
They cannot
it can
do
be
your
extended.
detention.
Yes.
Mm. Okay then.
But in the meantime, my lord, one page which was missing, but he is having in the records, my lord. I will request him, my lord.
Because, my lord, in that, my lord, paragraph, my lord, everything about the present petitioner. is-
No,
Yes.
that I am saying, let us. We are-
Because the paragraph, the 17th paragraph is half here in your
Yes, yes.
petition.
But we have
So
been
the
given,
observation made by the IO why he is subsequently supplementary charge sheet was filed, that observation is
so
there
that
in the
my
last
lord, we
page.
may have the solution. I don't know. my-
Copy.
Yes. We'll-
Okay, we supply the copy.
Yes,
We'll try to supply.
my
the
lord. But he may give my lord. It is,
My lord, because that copy is not with me, my lord. I have also gone through it.
No,
for
it
the-
is-
From record only, na?
so she may, my lord, he will give you.
A copy at us. Collected from the registry. She's saying that you can collect it from the registry only, not by her, by from the
Your
registry.
lordship will only make some observation, otherwise, or you may inform the registry.
But I cannot say because it is
Your
your,
lordship now.
we cannot make an observation or direction because your petition is half. Or do one thing otherwise. You try to get a certified copy of this charge sheet and
Yes.
file it on the
From here
21st.
also you can get, huh?
Yes. But that
Huh?
certificate copy.
Obliged.
Because one kind of or one sort of allegation is brought against you by Botakur that you have not filed the complete charge sheet. So we cannot make an
But we have been
observation.
given, my lord, what we can do.
No, no,
Maybe,
no.
I do
I'm not
know.
on that. You
No.
have not done
Yes.
this. But the question is that half charge sheet you have given, where the observation was that is missing.
No, that.
So
No,
make
that
a
one, it is
prayer,
on
get
the
a
spot.
certified copy, place it before us.
But in the interim may continue.
Interim was there.
Yes,
Where interim was there?
yes, in every.
In AB.
every day.
AB to the interim continue. Okay, we are continuing.
Obliged.
You are Mr. Ayu Chaudhary is assisting.
Okay. Keep it up.
Number was later. 1516. It would see a criminal petition to list on Imam Koil Deho. AB to Khali interim be continued till next.
17.
You are appealing for the respondent?
I'm appearing for the respondent number 2.
This petition perhaps my lord can dispose it today. What happened, my lord? Two enact proceedings were continuing, my lord. And this petitioner was accused, my lord, in two proceedings, my lord, that is going on, my lord. What happened in the COVID period, my lord? Only one day he was absent because of his illness, my lord. And also his daughter was seriously ill. She had to, kidney has to be removed, my lord. Only one day, my lord.
And that started the whole thing, my lord. NBW was issued, and my lord, he again immediately he took steps, my lord, but it was refused, my lord. And ultimately, what happened was they filed an application at page 52, my lord, in 102 under section 102 CRPC, page 52. Can just have a look, my lord. This is the petition they filed. Sorry. Oh, this is the impugned order, my lord, page 52, my lord. So 102 CRPC, my lord, they tried to apply in the NI proceeding, my lord. And the learned court below, my lord, had frozen the two savings account, my lord, in both the proceeding. Out of those two accounts, my lord, one is related to the pension account of the petitioner. And this person, my lord, he is without pension for the last, my lord, 1 year, my lord, because of the impugned order, my lord. And that is my whole case, my lord. And my lord, may I read the impugned order once, my lord? Page 52, my lord. Complainant is present, seen petition by number 5715 filed by the complainant under section 102 CRPC, praying for seizure of bank accounts of the accused person, so and so. Both accounts having been and which are involved in commission of deliberate offense of willful dishonor of multiple sex, namely SBI SIC number so and so, and Vijaya Bank account bearing number so and so, stating that on a bare perusal of subsection 1 of section 102 CRPC, it is prescribed that police officer has the power to seize any property which may be found under circumstances creating suspicion of the commission of any offense. That two preconditions are to be imposed for applicability of section 102 CRPC, which are firstly that it must be properties, and secondly, in respect of the said property, there must have been suspicion of commission of any offense. That the complainant most humbly submits that under section 102 CRPC, a police officer during the course of investigation can seize the property or prohibit the operation of bank account if such assets have direct links with the commission of the offense for which the police officer is investigating. Moreover, the complainant prayer for attaching the property in the name of the wife of the accused person has rejected by this court by order dated so and so on the ground that there is no information of any property belonging to the accused person. Heard the learned counsel for the complainant. Perusal of case record reveals that the accused is willfully absconding from the case as 2 NI cases are pending against him. Hence, considering the prayer for the complainant to freeze the accounts mentioned above is allowed until further order. The concerned bank managers are directed to do the needful after proper verification in the system of the accounts of the accused person. This is the order, my lord, impugned order. Then, my lord, I have thereafter, my lord, appeared, my lord. I have taken bail also, my lord. Because NBW was earlier issued, my lord. I have taken bail, my lord. On that page 104, my lord. Now, my lord, after I have appeared, first of all, my lord, this impugned order is not a reason order, is a bad order, my lord, because 102 CRPC, my lord, from the very definition of the my lord, provisions, my lord, it doesn't apply in an act proceeding, my lord. May I read the 102 section 102, my lord, for a minute, my lord. Section 102, my lord, it says power of police officer to seize certain property. No, there is no, this is not a stolen property, my lord. This is an NI proceeding. Legislated by is a separate enactment, my lord. Any police officer may seize any property which may be alleged or suspected to have been stolen or which may be found under circumstances which create suspicion of the commission of any offense. My lord, just because, my lord, NBW was issued, my lord, it doesn't make a case under IPC, my lord. It's an NI proceeding, my lord. Police officer cannot have any power, my lord. And this learned trial court, my lord, could not have applied this provision, my lord. It's absolutely illegal order, my lord. So, my lord, anyway, my lord, I have already appeared, my lord. That page 104, my lord, the warrant was already been recalled, my lord. Now, since the objective is to, my lord, the appearance of the accused, my lord, since I have appeared, my lord, there is no reason, my lord, to keep the bank account under freeze, my lord. So that is my humble submission, Lord. This order must go, my lord, and this pension account must be, my lord, open, my lord, because there is a livelihood at stake, my lord. The arbitrariness, my lord,
That has to be corrected by the Supreme Court. And I have given one judgment, my lord, the Tista Otu Sitalwat case, my lord, that is in the record. So there, my lord, it is very clearly stated by the Honorable Supreme Court, my lord. I just point out one para, my lord, para 19. In para 19, my lord, it says, in the case of Sri Jayendra Saraswati, the court, while considering a transfer petition under section 406 of the code seeking transfer of the court case pending before the principal sessions court, at Sengalapet to any other state outside the state of Tamil Nadu, adverted to the circumstance of a motivated order passed under section 102 of CRPC, freezing of 183 bank accounts of the MUD on the ground that the head of the MUD was involved in a murder case. In that context, it is observed that the power vested under section 102 CRPC cannot be stretched to irrelevant matters, to extremes and to breaking point. The power must be exercised cautiously, failing which the discretion exercised by the authority would be tainted with arbitrariness. So, my lord, hearing this case, my lord, this not even applies in an NIAC proceeding, my lord. So that is my humble submission, my lord.
May I please, your lordship? Lordship, the same interim order which my learned friend has quoted, here the para number, in page number 53, perusal of the case record reveals that the accused is willfully absconding from the case. And lordship, this offense was committed in the year 2017, and since case was filed in the year 2018. During the period 2018 till 2021, 27 times this matter came up before the court, and he had been absent from the court for 17 times. And since 2021 till 2024 December, he did not appear even for once. No representation, your lordship. And firstly, bailable warrant was issued. Thereafter, non-bailable warrant was issued, and we tried to attach the property which he had given in his bail address. We found out that the property does not belong to him, so that petition was rejected. We moved a petition praying that the help may be taken from the bailer. We found out that the bailer has also died. The accused has frustrated all due process of law. Then only the learned court below had taken such a drastic step of freezing his accounts. That to your lordship, he never approached or never alerted the court that these accounts are savings accounts or his pension accounts. It was just a bank account from which he had issued in check. We only had that much of proof that these are his bank accounts. His address was questionable because the property did not belong to him. Every time police went to the address, people around him gave the remarks that nobody knows about his whereabouts. Now they are coming with medical documents which shows that all the while he was sick, he was not feeling well, but they did not appear before the court and submitted the documents, your lordship. And even on the last date, when they appeared on 8th of November 2024, they came up with a medical documents which were old, very old. That's why the petition was rejected, your lordship. So now the bank accounts which they have submitted before this honorable court shows that he has reasonable amount of money in that account. Some amount may be deposited before the order of defreezing is issued, your lordship. Otherwise, he will again disappear. It's very likely to
trial is yet to commence, my lord. I have not admitted my due. So trial will reveal, my lord, if I am liable to if there is enforceable liability, the trial will say, my lord. And now, my lord, I have already appeared, my lord. Bail has been granted. There is no plausible reason, my lord, to keep my account under suspension.
And
so this is not a trial, my lord.
Fact of the case is he had issued one check which got dishonored, and second check which he issued before the learned court below, that also dishonored, and that was dishonored voluntarily. He went to the bank himself and stopped the payment. He did it willfully and voluntarily, while he gave the impression in the court that he is giving a check which is going to be get honored. So all this while his intentions are very clear, your lordship. If this drastic step was also to compel his appearance, your lordship. Otherwise, till date he would not have been come before this court.
All these things, my lord, he can tell before the trial court, my lord. all these things because this is not a trial court. My lord. I have filed a petition under section 482, my lord. And since even if had it been an order under my lord, 82, my lord, it is not an order under 82 CRPC, my lord. It's an order 102. Even if the PNA has been issued, my lord, that is in a limited for a limited person till the time he appears. Now he has already appeared, my lord. Bail has been granted on 10/12/24. Now, what is the reason, my lord, of keeping the bank account closed? So that is my humble submission, my lord.
Your Lordship, I filed
And
an IA.
regarding the deposit of certain amount, this is an absurd prayer, my lord, because that I have not admitted my dues, my lord.
He had admitted his dues.
No,
He
there is no
found
order
the
to that
check,
effect.
He presented the check and then he pleaded not guilty
That was-
after some 5-6 days.
So,
Your
my lord,
Lordship,
I
I filed an IA in this matter, praying to join two matters which they have filed, arising out of same cause of action, same complainant and the same accused. All this matter may be heard together and disposed of together, Your Lordship.
Other matter is also there?
No,
Yes,
my
yes,
lord, there are
yes, Your
two,
Lordship.
my lord, they file surreptitiously, they file another complaint case, my lord. There's a different aspect, my lord. I have filed another criminal petition, my lord. In that case, my lord, stay was granted. Stay of the proceeding was granted. Now she is trying to club all these things.
Yes, Your Lordship.
Apps now, before your lordship, my lord, only two complaint cases are there, my lord, that I have mentioned. It is not related to other things.
Your Lordship, in the trial court below, two complaint case and one PRC case is going on against the same accused person. That one PRC case came out from the complaint case when the accused did not appear at all. Then the police filed a final report and a PRC case was initiated, Your Lordship. That case has been stayed. Interim stay order was granted by this honorable court. My prayer through this IA is to merge those cases and heard together because the cause of action is same. The first offense.
What is the purpose? My lord, let me explain, my lord. What happened, my lord? Out of the two NIA proceeding, my lord, they filed a complaint case saying that I am, my lord, they filed an FIR before the Lotus Hill police station earlier, my lord. Clubbing the facts of these NIA proceedings, my lord, mentioning all unnecessary things, my lord. So police registered a case against that case, my lord. Charge sheet was filed. So cognizance was taken. I have filed a petition, my lord, for quashing the entire proceeding, my lord. Stay was granted in that property.
Your Lordship,
So
we
it has
have not-
nothing to do with these two NIA cases that is before your lordship.
Your Lordship, we
So
have
let
not
us
filed an
not
FIR.
confuse your lordship.
We have not filed an FIR.
No, here, this criminal petition is for washing of one eye, two NII.
No, one common order involving two NIA proceedings.
Your Lordship,
One common order, my lord, involving.
This the order in page 52 is
Yes,
common order.
Common order, involving two petitions, two NIA proceedings. Because, my lord, there were two accounts were there. In one proceeding, my lord, SBI account and another proceeding Visa Bank account, my lord. So they have filed a petition clubbing all two proceedings, my lord, and the learned trial court has passed an order, common order.
Your
That
Lordship.
is why I have filed this petition.
Your Lordship, the other quashing petition which they have filed, that one also, we have not filed an FIR. We had filed a complaint petition, which was later sent to Thana for investigation as the accused was not appearing.
Later on, it was converted to FIR. Please
Because he
go
was
through
not
your
appearing,
records.
Because he was not appearing. We had not filed an FIR. We had
That's
not
a different issue, my lord. Nothing to do with this proceeding.
All three matters are
So, my
connected.
lord, if she has also a prayer, my lord, that my lord, expeditious hearing of the trial, expeditious, my lord, proceeding has to be expeditiously, my lord, taken up, my lord. If that is so, my lord, okay, my lord, I will face the trial. Let the account be open, my lord. And because I have already appeared before the learned trial court, bail has been granted. So there is no reason.
Here you have amended.
My lord.
Here you have mentioned that the amended order was passed. Sorry, the impugned order was passed in connection with CR 1436.
1436, yes.
And other one?
Other one, my lord, this one, 748 of 2020. One is CR 1436 of 2018. And another is CR case number 748 of 2020.
748.
748.
Your Lordship, these two matters are not clubbed. We are taking the similar dates and running it simultaneously, but it's not clubbed.
No, one order was passed, right?
One order was passed, Your Lordship. It's not.
That is the impugned order on 18-1 is passed.
Pass for both the proceeding.
we were trying to get.
For both the
common-
proceedings.
Yes, yes. Because my lord,
Not here only.
my lord will see the account number were mentioned, my lord. In the,
It was passed in connection with only 1436, not for 748.
no, my lord, 102.
I don't know, from the order itself, it is in.
Yes, my lord will come to 102, my lord, for a moment of the impugned order.
Huh?
Kindly see
10,
102, my lord.
page number.
Yes, of my petition. So, my lord, this order involves, my lord, two accounts. Account bearing number.
No, that is your case, but the
Yes.
question is the order was passed only in connection with 1436.
146. Yes.
It's not there,
As it
anything. There
appears,
may
yes.
be two accounts may cease, I mean freeze, but the question is that only one in constant to CR 1436.
146. Yes, as it appears. Yes.
So was 74748 is also pending.
Yes, it is also pending.
Okay.
In the, your lordship, the fact of that case is 1436 was the first case, and in that case, he presented a check in the court, admitting his
That was
liability.
also,
And when that got dishonored, 748 was filed.
No, my lord, it would be wrong to say I admitted by liability, my lord. I don't know, my lord, the advocate concerned, my lord. I don't know how it got gone into, my lord. So I was told to present a check, my lord. But the order sheet clearly says, my lord, I will show to you, my lord.
no,
that-
why you are told to present a check?
my lord.
Your lordship, he has admitted his liability
Because
and paid
suppose
35,000
you
rupees.
have not admitted your liability.
Yes, ma'am.
Then why court will suggest you that you
No,
present a
court
check?
did not suggest, my lord. The advocate, my lord, advocate that I, my lord, engaged, my lord.
Ah.
It was, I don't know, I was instructed like that, my lord.
Hmm.
So he was told to, I was told to submit one, present one check, my lord. But in the order sheet, my lord, kindly see page number, my lord, kindly see the order, my lord, just page 23, my lord.
With
34,
the order
34,
of
page 34,
cognitive.
page 34, my lord, page 34. Both parties are present. The order of 18/1/2020, my lord. Both parties are present. With particulars of offense under section 138 NIX read over and explained to accused person to which he pleaded not guilty and claimed to be tried.
This was after the second check got dishonored, your lordship.
So then, my lord,
If
and my lord, 33 what's
your lordship, page number 30 of their petition, order dated 15/5/2019. Both parties are present and stated that the accused paid rupees 20,000. Accused had paid rupees 20,000 in the court. In total, accused paid rupees 35,000 in the court, admitting his liability, your lordship.
No, page 30, order dated 15/5/19.
Yes. Three payments were made.
Where from you are saying?
page 30, my lord.
Page 30, order dated 15/5/19.
Ah.
20,000 was paid by the accused to the complainant. Total, he paid 35,000 in the court to the complainant in separate dates.
But that doesn't speak about the whole liability, my lord. Even if we for the time being, my lord, admit
What was the check amount?
one is 1 lakh,
Second December check
50,000.
was for 1 lakh.
and one is 1 lakh.
Second check is for 1 lakh.
Which he voluntarily went to the bank and stopped the payment. Your lordship. That he has admitted in his own petition, which he has filed before this honorable court.
But subsequently, he is to pay as a whole 1 lakh.
Yes, your lordship. The initial check amount was 2 lakhs.
1.5 lakhs, not 2 lakhs. Finally say.
out of which he paid 35 in the court and 1 lakh he paid through check, which the complainant at that time also denied to accept considering his track record. But he pleaded before the court that it will be honored. But next day itself, he went to the bank and stopped his payment, Your Lordship. That he has completely in his book, in this petition, he has agreed that he himself went to the bank and stopped the check.
So all these things, my lord, are matters of trial, my lord. My lord,
For matter
well, I am
trial to take place, accused has to come, Your Lordship. He is not appearing since
oh,
2021.
I have already taken, bail has been granted, my lord.
Where was he all these years? 2021.
No, that is not your
2024?
problem.
Why-
My lord, my lord has, the learned trial court has already granted me bail, my lord. That means, my lord, I will be appearing in the next days to come, my lord. I will be facing the trial. And why she has got some anxiety regarding that, my lord? I will face the trial, my lord.
That has to be
And
ensured. Your Lordship.
and
That
since
has
I have
to be
appeared, my
ensured.
lord, there
Since
is,
there was a bail earlier also, bailer died, nobody was appearing. We cannot trust
My
so
lord,
easily, Your Lordship.
I have
Because
given
3
all-
years is
all
not
explanation.
less time. 3 years, Your Lordship. He was absconding for 3 years. And absconding was also declared. Proclamation was also issued, Your Lordship.
my lord, I may not have to, my lord, submit before this honorable court, my lord, because pension account cannot be blocked, my lord. Pension account, my lord, pension now, no, my lord, because of this impugn order, the whole, my pension amount is blocked, my lord. I am not able to survive. There are a lot of, I have judgments with me, my lord, but I don't think that will be required, my lord, because how can the pension account be blocked, my lord? So, my lord, because of this faulty order, so I'm not having the benefits of my pension, my lord. Now, my lord, my humble submission, my lord, let this freezing be go, my lord. Let me face the trial. Till the time, my lord, this impugn order has to be set aside, my lord.
Your Lordship, to ensure his appearance, some amount may be deposited at the trial.
No,
court,
that is
Your
that is
Lordship.
an absurd
Because-
prayer, but I object to that, my lord.
It's not, he is very.
No, that cannot be put. I have challenged the legality of the order, my lord, passed under section 102 CIPC, my lord.
Heard Mr. R. Chakraborty, the learned counsel for the petitioner. And also heard URMS,
S. Sharma.
S. Sharma, the learned counsel appearing for the respond number 3 or 2? 2. And also heard Mr. A. Khanikar for the respond number 3. You are 43. You have anything to submit? Or your state bank?
No, I'm not. Because of impugn order, the bank account has been freezed.
Okay.
Well, there was an inquiry by another coordinate bench, my lord, whether this account is pension account or not, my lord. That is why, my lord, my friend has, my lord, appeared, my lord.
Pension account. Chakraborty, so and also Khanikar, so and so for the respond number 3. This is an application under section so and so in connection with so and so. Stop. Next para. Mr. Chakraborty, the learned counsel for the petition submitted in this regard that the accused petitioner was appearing before the learned trial court below. However, during the COVID period, his daughter has to go for an operation for kidney transplant, and for that reason, he could not appear before the learned trial court below on some occasions, and for which NBW was issued against him. However, he subsequently appeared before the learned trial court below, NBW was recalled, and he was allowed to go on bail. But during his absence, considering the submission made by the during his absence, a petition was filed before the learned trial court below under section 103 CRPC for seizure and freezing of the 2 bank accounts of the present petitioner. Considering this full stop, considering the submission made by considering the submission made by the respondent side, the learned trial court below had freezed both the accounts, namely one SBI account, SBI Bekatot Bamoni Madam accounts branch.
My lord, Bamuni Madam, New Guwahati.
Madam, bearing AC account number 1056 7107
604.
604.
Yes.
This is your pension
Pension
account,
account, new Guwahati branch.
which is his pension account. And another account in Vijaya Bank, bracket or Silpukuri branch. The account bearing number 80110101. No, sorry, 801101110000864864. It is observed by the learned trial court below that the accused petitioner was willfully absconding from the case from 2 NI cases as pending against him. And hence, considering the prayer of the complainant, the learned trial court below had freezed the 2 accounts as stated above. Poster. Next para, Mr. Chakraborty further submitted that the section 1021 CRPC is not at all applicable in cases of NI cases, wherein the section speaks about it's about the power of a police officer to seize certain property. When if the police officer suspects that wherein the police officer may seize any property which may be alleged or suspected to have been stolen, or which may be found under circumstances which create suspicion of commission of any offense. But this application, but this 102 CRPC is not at all applicable in the case of an NIA proceeding, wherein it is not a question of stolen of property, etc., or nor there is any commission of offense as described in the 102 CRPC, section 102 CRPC. More so, the courts took all the measures only to procure attendance of the present petitioner, and he accordingly appeared, he was enlarged on bail, and now he is regularly appearing before the learned trial court below. He further submitted that this account freezing of these accounts created very much with problem with the present petitioner, as the SBI account is his pension account, and for which he is not getting his pension since last 1 year. Accordingly, it is submitted that the order dated 18/1/2024 is liable to be set aside and quashed along with a prayer for freezing, along with a prayer for defreezing the accounts. To defreeze the above stated accounts number so and so. Next one. MS Sharma, the learned counsel for the petitioner, submitted MS Sharma, the learned counsel for the response number 2. 2 nigini. You are for 2, na? 2 submitted in this regard. That that all the order of freezing those accounts had to be passed by the learned trial court below, as the accused petitioner was absconding since last 3 years, and case is pending since last 2017. And in 17 days, he absconded and did not appear before the learned trial court below. Even after issuance of NVW PNA was there,
He remained absent and then absconded.
17 times he remained absent, and thereafter he absconded, for which the NVW and PNA had to be issued against the present petition.
My lord, it may not be correct, no, 17 times, my lord, because I was represented by my advocates, my lord. So how, if he have counted it correctly, then I have nothing to say, but I don't think so, my lord. 17 times he got absent, my lord.
Low court records, your worship.
No, my lord,
27
that has to
days.
be, that is disputed, my lord.
In this context, Mr. Chakraborty raised objection and submitted that he never remained absent for 17 times in a court. However, he may not be physically present, and he was represented by his engaged counsel.
17 days were absent petitions, your worship.
Next
It's
para.
counted.
Next para. The MS Sharma further submitted that he already admitted his dues before the court, and in pursuant to that, he has already paid altogether rupees 35,000 before the court. And during the pendency of the present case, that is CR 1436 of 2018, he also presented a check before the court to clear his dues, but subsequently he stopped payment of the check, and for which another NI case had to be instituted against him, which is registered as CR number 748 of 2020. So considering his conduct and willful absence, the court had to pass a strict order of freezing his accounts, only to procure his attendance, full stop. He further submitted that an order, if there is an order for defreezing the accounts, the accused petitioner may be directed to deposit some amount of money before the court, so to procure his attendance, full stop. Next para. Mr. Chakraborty raised objection and submitted that he has not yet admitted his dues, and matter is under trial, and hence such kind of order may not be passed at this stage, full stop. The order of freezing the accounts were made only considering his absence, but presently, as the accused petitioner is appearing before the learned trial court below, such kind of, there is no necessity of passing such kind of order. No, again. Such মিলাই দিব কিবা এটা, অলপ ব্ৰেক হৈ গৈছে লাইন। Next para. Mr. Khonikar, the learned counsel appealing for the SBI oblique response number 3, submitted that the SBI account number so and so pertains to his pension account, which is a pension account, and submitted that the court may pass necessary order accordingly. Next para. Considering the entries, submission made by learned counsel for both sides, I have also paid his record, and so. From the record, it is seen that we have not annexed the all order sheets, no?
It's 23 onwards, my lord.
53 on.
23, my lord. Annexure A, 23 onwards. And in fact, I have just checked up, my lord. My learned friend is wrong, my lord. All the dates, my lord, she have mentioned. I've been represented by my advocate, my lord. Accused absent with steps. What does it mean, my lord? My lord, she should not have made such kind of submissions, my lord. Kindly see, my lord. Even she, the complainant she herself was absent, my lord, in many dates.
Your Lordship.
And I used to stay at Silsor, my lord, during that period, my lord. Doing after retirement, I had to do my job, my lord, because my lord, I had very, my lord, financial crisis was going on, my lord.
Your Lordship, the petitions filed before the learned court below says the accused informed the learned counsel on the phone that he is not available, that he is out of Guwahati, that he is on.
No reasonable ground was there.
Reasonable ground, Your Lordship.
On the result of the record, it is the record and the annexures filed along with the petition, including the order sheets. It is seen that admittedly the case was pending since long, and there was on several occasions the accused petitioner remained absent through his remain absent with steps. And in the same time, it is also seen that in some occasion the complainant also remained absent. But considering his long absence and the long absence and subsequently he absconded, no, considering his long absence in the court, the learned trial court below had to issue the NBW and PNA against the present petitioner. However, at present, after he surrendered before the learned trial court below, and accordingly, his NBW was recalled, and presently he is appearing before the learned trial court below. It also cannot be denied that the section 1021 CRPC is not directly applicable in a case of NI, and whereas the police was provided with the power for seizure of the property as advised under section 102(1) of the CRPC. However, the court had to pass such kind of order only to procure the attendance of the accused petitioner. And at present, it is seen that the accused appeared and now appeared before the court, no, surrendered before the court, and accordingly he is appearing before the learned trial court below. Coming to the issue next, coming to the issue raised by MS Sharma, the counsel for the respondent number 2, that there has to be an order for depositing money may not be considered at this stage because the trial is still going on, and it is a matter of the trial as to whether there was any legally enforceable debt against the present petitioner. First with petitioner first. So considering the details discussion made above, considering all this so and so, the present petition for setting aside and quashing of the order dated 18/1/2018 18/1/2024 is hereby set aside, and the 2 accounts which have been an order for freezing 2 accounts number so and so is hereby set aside, and bank authorities are hereby directed to defreeze those accounts which were seized in connection with this case, wide order dated to 18 so and so. However, the accused petitioner is hereby directed to appear before the learned trial court below on each and every date to be fixed by the court, and the learned trial court below is also hereby directed to dispose of the matter expeditiously. Bank authority direction with the observation this license disposed.
Obliged.
ব্যাপার আছে দে। এইটো সব চাই দিম দিয়ক। এটা কানেক্টেড আই এটা। পেন এটা গুচি গ'ল নেকি? উইথৰ ৰেকৰ্ড ওৱান পেন গুচি গ'ল নেকি?
That is not.
Awaited.
In this case also, my lord.
LCR and CD is awaited.
Lordship, yes.
You have file received?
No one.
To fix another date.
Account
TD
was
will be-
freezed, lordship.
Huh?
Hearing this also, my lord, account was freezed, lordship.
No, whatever, we need the record.
My lord, short date may be.
Short date, next week we don't have any date. Because it has to come.
But hearing the.
At least we can fix it after 2 weeks.
Lordship, date may be fixed, lordship. Otherwise, it is very difficult to get.
What
the
to
case
do?
fixed.
We are difficult on our part also to deal with all the cases, 70, 80 cases. These are difficult on our part also. But to
My lord, urgency is there, my lord, business is, my lord, completely stopped, my lord, account is freezed, lordship. This is my lord,
after a week, any date to fix.
means of livelihood is there, lordship.
After 2 weeks. We have to date and fix any. Court of appeal. Court of appeal. CD along with the scan copy is not yet received. Issue reminder. Rest you will do it in it.
All like lordship.
19. Oh, আমি appoint করব লাগবে না?
Criminal appeal jail, man.
Criminal appeal jail. This is an jail appeal. Filed against the judgment and order dated judgment and order dated 27/09/2024 passed by Learned Special Judge POCSO in case number in Learned Special Judge in special packet of POCSO case number 65 of 2023. It is Sipsagar, Special Judge Sipsagar লিখে দিবেন। Whereby the present accused appellant was convicted convicted under section 376 IPC, read with section 4 of the POCSO Act. And sentenced to undergo RI for 10 years and also to pay fine of rupees 5,000 in default, RI for another 3 months. Heard Mr. Botaku, the learned additional PP appearing for the state respondent. Raised you have I directed to appoint will be, yes, as in suggestion. Amicus regarding.
Yes, my lord.
Estas quid. Hereby Estas is okay, but I think.
Yes.
Estas. So it does. Is hereby directed to appoint Mr. Surajit Das as an amicus to represent the appellant. Here too, we have to issue notice also.
Yes.
Also issue, who will take steps? Huh? No, it was section 4 also. For your record. After that, okay. Will let the appellant be appear through amicus, then only will get it. List accordingly after 3 weeks.
Item 20.
May I please? See, I'm appearing Mr. We deny his some personal detail left the court. So may I pray if Lordship make convenient and let the matter fix the next week, can it do?
Date cannot be there, then next week it will be fixed by up to registry only. Is there any interim operating?
No, there isn't.
No interim. The thing is, Lordship, the petition which they have come, this is an enacted proceeding, Lordship. Because the submission helps us, and the such last occasion court did not call the case record scan copy because as the same was not required. The thing is that he is not challenging.
He is not in a position to serve.
That's why, Lordship, the thing is that, Lordship, this morning, because the pendency, lower court doesn't proceed with the matter. That is the main difficulty, Lordship. So if because tomorrow is the date, that's why, Lordship, last 2 or 3 days back, the date was fixed today. This morning, he has also not intimated me even also. That this is the problem.
I'm not mentioning in the
Lordship. The thing is that, Lordship, only if the matter be fixed up on the next 24th any day, this will end up. What happened, Lordship? The thing is that sometimes some matter are pending that the trial court doesn't proceed with the matter. This is 2019 Act. A DW cross examination is complete. Plaintiff complaint cross is completed, and thereafter, when his evidence was come up, then he is filed this petition section 91 CRPC. Then court is subject just to delay the process. This petition is filed. There is no use of because no dispute in respect of the issuance of check. Not the because he admitted the liability 313 instead everything there. What is the use? Then he filed revision. That court also point out the same view and rejected the same. So last occasion the court take up the matter. Then they fix on the 17th. So my humble submissions, Lordship, this matter the previous Act 2019. Unnecessary just to delay the process. So if the matter will fix up 2-3 weeks, it will not come up later. Even the problem get lower court will keep the matter because as the matter is pending before the High Court, so will not proceed. That is only the main difficulty in the particular matter. Because he dealing to DW. Now this petition, complaint petition where there is filed trial court, then revision court is filed that petition named against that challenge he come up there. If anything comes up regarding the dispute of the check, then the matter is different. So the humble submit 24th.
Second. End of March is not possible. 2nd April.
2nd April.
Yes.
Okay, that's then.
On behalf of Mr. P.D. Nair, the counsel for the petitioner, adjournment prayed for. List the matter accordingly with consent querible. List the matter accordingly on 2nd of April. 2-4.
But can it be come up with the above the admission list? Because again the thing will come. No, admission cannot be.
Obligors.
21.
May I please, Your Lordship? In this case, can copy was called for. I think it is come, it is come. But it will take little more time also.
Scan copy has already come.
So may I place a detailed accommodation for any other date? Next week, any other day.
Next week may not be possible. End of the March already lots of matters have been fixed. Yes, can it be when it can be? First one, I keep aside with no April.
First week of April,
8th of April.
first,
Can-
8th of,
Yes. 8th of April. Okay. যেহেতু পসিটিভ করে দেবো না 8th of April.
23.
Lordship,
Yes.
On the last occasion, report was called for. This is a
Report.
petition, Lordship.
We have received the report, not received.
Lordship, I would like to pray for a short date as the seas are gonna.
Short date may not serve your purpose, so yes, that's when it can be.
it is from Hosea, Lordship. On 28
28.
March.
Heard MSP Bora, the learned counsel for the petition. Also heard Mr. Anandas, the learned, oh sorry, KK Das, the learned additional PP appearing on behalf of said respondent. Report not received. To reminder, this is the matter according to 28.
Yes, Lordship.
Matters for orders, item 41.
Meet please, Your Lordship. Lordship, there is an IE, Lordship.
রাতিপুৱাটা হেৰি কৰি আছিলে যে। অ 45 44 কিন্তু আছে নেকি এবাৰ মান petition ন? 44 45 444 45 কি হ'ল 45 the morning he tried to mention it but as it was connected with before yes yes 41
Lordship, there is an IE, Lordship. I want to point out, Lordship, that our High Court practice is that, Lordship, when an application for rectification in an order is passed, Lordship, it has to go before the concerned judge. Lordship. That is what I'm trying to emphasize, my Lord. Because there is an error, Lordship, that has corrected in the order which was passed by the court. Lordship, that is the.
which court this one
Lordship, Justice S.K. Bhupal. Error in the order, Lordship. As it was pointed out on the last occasion also, Lordship, Justice Mridul Kulita has also spelled it out. That it has to go before the consent. So, Lordship, that I just wanted to point out on the Lords.
no obviously
My Lord
it is the
that is the practice in our High Court, Lordship. So, my Lord may make an observation to that effect.
I introducing one I
The order is at page number 10. My Lord's confirmation. Of the IE.
okay so I is for correction no?
I is for correction only.
You are Mr.
H. Betala.
H. Betala, the counsel for the, I to click you, counsel for the petitioner. And also her, you are appearing for the respondent.
Respondent number 2.
SK Gupta for the respondent number 2. It is submitted by Mr. Betala that the order which was supposed to be corrected was passed on 23/07/2024 by Honorable Mrs. Justice SK Count, SP Count, SP count, SP count. Next para, considering this submission made by the counsel for petitioner, let the matter be listed before the appropriate bench. Registry will do the needful accordingly. You want any date after what? After week? After week?
After, not lordship, a fixed date may kindly be fixed.
Why?
That's if they are enjoying the interim there, lordship.
But that is on the basis of a prima facie observation of the court, my lord. I don't know how my friend is prejudiced by that.
This after a week, it will be date fixed by the registry only. Okay.
42.
But if the interim may continue, sir.
Yes, yes, interim be continued till next date. Okay.
Obliged.
May I please do lordship?
Hmm.
Lordship, kindly peruse the office note dated 12/3/25, lordship.
LCR along with this service report is awaited, no? Let it be awaited till next date of listing then. URMS,
D. Devi, lordship.
hard MS D. David, the learning counsel for the petitioner. As per office note dated 12/3/2025, both the service report and the LCR is awaited. Let the service report and LCR be awaited till next date of listing. Yes, you are appearing. For? Response number 2. Okay. Okay, then service is completed. Okay. Service, no, not the Leki doctor cut off some. Her sense of video. LCR is awaited, however. Learned counsel, you are Mr.
M. Hendy.
M. Hendik. He appeared on behalf of the respondent number 2. Have you filed for Bakalat Nama also? Today you have filed Bakalat.
Today.
And he submitted that he has already filed his Bakalat Nama today.
So,
Thus, the service is already completed. Full stop. However, Mr. Hendik submitted that he needs some time to file his affidavit in opposition. Prayer allowed. Registry matter report. The prayer allowed. Full stop. Registry is also hereby directed. Registry is accordingly directed to issue reminder in calling the scan copy of the LCR. List accordingly after 2 weeks. 2 weeks will do. List after 2 weeks. Okay.
43.
Yes.
My lord, I refer to page 15, my lord, of my IA.
No, what is the IA for?
IA for my lord, suspension of sentence and grant.
Otherwise, case is ready.
My lord.
Case is, what is this case? Huh? SC has been received. So let it finally be heard.
And this matter will be listed along with appeal number 68/2025.
Appeal number?
Criminal appeal number 68/2025.
68/2025.
And we file appeal for enhancement of sentence.
Oh, you have already filed. What
And
was the
then-
term of sentence?
Sentence 8 years.
8 years, ma'am.
8 years.
Double murder case.
What you
Double
say?
murder.
Huh.
The landed court below convicted 8 years. Convicted contractor 304.
Oh, 304. Achha.
But case has been stabilized under section 302. How the court below sentence?
No, established
My lord.
select part, but the question is that as per the learned court below's observation, it
304
comes
part
under
2.
304, I think.
Part 2.
Part 2.
8 years, my lord.
That is why I file a appeal for enhancement of the sentence.
My lord, my humble submission before your lordship, as on today, we have completed 124 days in custody. 44 days. So, my lord, my humble submission before your lordship, as 8 years imprisonment, my lord. 8 years imprisonment. And there is something, my lord, I want to point out one thing. My lord, the judgment is passed on the basis of eyewitness. 3-4 eyewitnesses. And on PW7, my lord, stated
No, I'm
that-
not going to hear the matter.
Not
today.
In that case, my lord, your lordship, I am referring to some judgment. My lord.
No, I'm not going to hear the matter today.
My
That's
lord.
what I'm saying.
My
It
lord.
will be listed along with criminal appeal 68/2025 as
My lord,
And
that is
LCR
my-
will
my
follow
humble
same
submission-
two of this.
My lord, my humble submission before your lordship regarding enhancement of sentence, my lord, has no business to deal with the case, my lord, regarding bail. My lord,
No, I'm not on that. We are finally going to hear the matter as LCR has already
My
been.
lord,
received.
our final
That's all.
hearing of the matter, my lord, that will prejudice me,
that
my
will
lord.
do.
Your lordship,
Your petitioner is only 144 days behind the bar.
140, my lord,
It's
bail.
okay,
bail
144 is
my
a
lord,
case of
That is why,
2024.
my lord, I want to place some decision.
No,
before your
I'm
lordship.
not going to hear the matter, in fact, that's
My
why
lord,
I'm.
without hearing
Okay,
the
hard
bail, my
verdict,
lord.
sir.
My lord,
Hard, Mr.
let
Yamesh.
me submit, my lord. Without hearing me, my lord, on bail, if your lordship straightforward list it for hearing, it will be prejudice to me, my lord.
Okay, we'll see to
My
it.
lord.
Hard,
It
Mr.
may be,
Yamesh,
it
the
may be
learned
for
counsel the
bail
petitioner.
hearing, my lord.
Learned counsel for the petitioner. Sorry, a petitioner oblique appellant and also heard. Otherwise, you are appearing for response number 2. 2 and 3. And also heard Mr. P. Botapu, the learned additional PP appearing on behalf of state respondent.
2, 3 and 4 also, my lord, because one is minor.
Only 8 years imprisonment, my lord.
And also has Spencer appearing on behalf of respondent number 2, 3 and 4. Full stop. It is from record, it is seen that the LCR has already been received, and accordingly, this court finds that the matter may be finally heard and decided, and hence let the matter be listed along with criminal appeal number 68/2025.
A date may be fixed, my lord, in that
After
case.
2 weeks.
A date may be fixed.
After 2 weeks, we'll fix another.
A date may be given.
10th of April.
10th
10th of April.
44 and 45.
45 to 9, I guess. So you are appealing for 44.
45 days.
45 day pay for an
Yes,
adjournment. in
Of course,
fact.
my lord, that can be.
That can be.
Yes, my lord.
Okay, then.
On 3rd of April, most probably.
No date, we didn't get any date. You want 3rd of April?
Yes, my lord. Because
Why these are in order column? I is
there, yes.
I is for suspension.
Suspension, yes.
To positive COVID 3rd April COVID. Okay, then we are fixing it on 3rd of April.
Obliged.
46.
Next years, as per official matter dated.
Your
12/3/20
LCR and services awaited, na?
Yes, ma'am. 12/3/2025.
So how many respondents are here? Private respondent is 1 only. One Srimati Sunmoni Deuri. Also and so as per office note dated 12/3/2025. The scan copy and the LCR is still awaited. No, sorry. Service report on respond number 2 and the scan copy of the LCR is still awaited. The registry is accordingly directed to issue reminder to call for the scan copy of the LCR. Let the service for the respond number 2 be awaited till next date of listing. List accordingly after 2 weeks will do.
No. So far 47, 48 is confirmed, and I'm also in this case, my lord, in this case, due to oversight, my lord, we could not take steps. Today we have taken steps, my lord, in 47 and 48.
Only do. No, it is 40. We are on 46 now.
46.
After 2 weeks, 46. What are you saying? 46 and
In 47 and 48, my lord, due to oversight, my lord, I could not take steps, my lord. Today we have taken step, my lord. 47 and 48.
in both 47 and 48. 47 and 48 বেলেগ বেলেগ order হবো same দেখো
Petitioner.
Heard Mr. I. Chaudhary, the learned counsel for the petitioner. It is submitted by Mr. Chaudhary that due to oversight, the steps could not be taken against the respondent. However, you have taken steps today. However, the steps have already been taken today. This the matter accordingly after 3 weeks.
Interim is done.
Interim, in interim, which one?
Both the cases.
Interim be continued till next date of listing.
Obliged.
55. The Lordship, the present petition is filed for question of clear case 65C/23 pending before SDPL Nahakotia. The said case is for recovery of Spridhan articles from petitioner number 1 and
Yeah, only sole respondent is there, na? This respondent is awaited. AD card and it was sent to district magistrate, that has been awaited.
Lordship, we have.
You have taken
for
steps,
site,
but steps is awaited.
but
We have not received back.
The case is
Do you
pending.
have any other alternative address then?
No, your Lordship, we don't have any clue of any other address.
If any proper or alternative address you have?
We don't have.
Maybe Lordship. Lordship, actually, that address has been given by her herself already in the lower court case here. That has been filed by, the CR case has been filed by the respondent of this.
Then do one thing, if it is, you have taken steps 2-3 times.
Yeah.
Then this time you take steps, fresh steps through jurisdictional police station, routed through the office of the registry. That may help you some way, because if through police, if it goes, otherwise, if it is the order is proper, then somewhere or somewhat she might be avoiding the
Yes.
service
that
also.
is actually the.
So,
Lordship, there is a prayer for interim.
interim was there.
Yes, no, interim was not there. Prayer for interim is there.
Oh, no, that I cannot consider at this stage now. What was the case otherwise? Is it case of?
The CR case filed by the respondent for recovery of a Sweden,
Oh, state.
as she said. But she has already submitted 3 lists of Sweden. One she already received. One list of Sweden she have already received. Then it is going on and on, Lordship. So that's why there is, if I go to
First
the.
date of heading, you could have mentioned for
Yes, but the.
prayer for interim, it's not there, so I'm not in a position to stay now. You are Mr.
And Sharma, Lordship.
and Sharma. Heard Mr. and Sharma, the running counsel for the petitioner. From the office note dated 12/3/2025, it is seen that the service is still awaited for the sole respondent. Stop in that context, Mr. Sharma submitted that he has already taken steps 2-3 times to the respondent and she is avoiding the service. Considering the submission made by learned counsel for the petitioner, let the fresh notice be issued through jurisdictional police station routed through the office of the registry. Not like through jurisdictional police station.
So can it be fixed before 5th?
Huh?
5th of April.
No, service will be awaited, na? 5th of April, service will not become. You have to await for the service also, na? It will be listed after 2 weeks only. Date to be fixed by the registry.
Yes. Can it be fixed and date may be fixed also?
No.
Third of April.
Sorry, 2 weeks, after 2 weeks.
Fixed.
Service report is awaited here.
A scan copy of the lower court records was called for.
That has been received. We have received.
Lordship,
Service is awaited now.
Yes, but my humble prayer is for interim, and I think on the last occasion, sorry. No, Lordship, may I submit Lordship in this?
No, I'm not going to hear interim. You
Lordship.
could have pressed it for interim in the first day of motion
Firstly,
itself.
records was called for, it was not
No,
there.
first day of motion itself, you could have
On
prayed for
that
interim.
day, records was called for
Sorry.
scan copy. And then on the last occasion, on 10/3, scan copy was not there. Today, if scan copy is there, an interim to be considered today. I think on the last order, it is reflected
Okay, no,
also.
Heard MS D. Ghosh, the learned counsel for the petitioner. It is seen that the scanned copy of the case record has already been received. However, the service report on respond number 2 is still awaited. Is the matter, you want to take fresh steps or you want to
No.
await? Await.
Wait, Lordship, because today
Yes.
is fixed because we were waiting for the scan copy. If scan copy,
No,
nothing
no,
is
no, no,
there.
I'm not on that. You want to await the service or you want to get it fresh?
Not fresh steps, Lordship, we'll await for the,
Still awaiting, okay.
because
We awaited for
interim may be considered, Lordship. On the last occasion,
list accordingly on. We could have pressed for interim in the motion stage. Now, why, maybe there may be some reason why it was not granted.
Lordship,
That's why I'm
because
not in a
is the reason scan copy was called for, Lordship. May I just submit?
No,
It's just
sorry,
a
sorry.
concocted story, Lordship.
No, sorry, I'm not
Because
going
it's,
to hear the
and
matter.
there was delay in registering an FIR and there was no reason, Lordship. Because
Fix এটা date
since
দিব নাকি? Date fix হলে লাভ হবে জানো? After 2 weeks, any date can be.
Lordship, next date is there on 24th. Before 24th, I will press for any date.
24th.
The
Possible.
lower court, 24th, the matter is fixed.
Before 24, we don't have any date, I think. 21st at best. Are you?
Yes, 21st, I'm ready.
Okay, 21st.
21st. Lordship. Deeply obliged.
48, item 49.
With regards to this matter, kindly the matter may be passable for delay. The conducting counsel has to leave the court premises due to some personal difficulties.
Well, Mr. Borwa was there.
Yes, Lordship.
Submitted that the conducting counsel, Mr. K. Borwa, had left the court due to some personal urgencies, personal reasons. It's a matter of 2023, na?
Petitioner has been behind the bars for almost 2 years now.
2 years.
So, sure.
So okay, then we are listing it after 2 weeks, but date cannot be possible at
Lordship.
list after 2 weeks. You are appealing for whom? Here in 50 in item number 49. Okay. MSB Chaudhary, na? Hard MSB Chaudhary, Poetable, learned amicus, appealing for the respond number 2.
Deeply obliged, Lordship.
To 1 week back. After 1 week. Sharmila also got it. Yeah, I did get it. No, it's still 445, right? 445. Because 430 is still 445. Get to war. Those orders that comes in the last. In some court orders, they take it up. Now, Oh, I think update. Nine. Upward him. Oh. Thank you. Of course,